So, hello, Jax West, Stephen Avery Project, MAM Gossip, Justice with Jax, WMP Justice Review. We had been going over Kathleen Zellner's October 2019 brief to prepare for the state's response that was due on the 29th. They filed it today, which is May 27th, 2020. And I had just been reading an article that the state has responded, Tom. The link that I just posted above you is where you can read it. And I am about to read the state's response. So this is brand new. It is 130 pages. So this may take a while. While I'm reading this, I do not typically see your comments that you post, but Stephen Avery Project moderators will be on here to answer any questions. And thank you, Christina, for sharing it in the Stephen Avery Project group and MAM Gossip. So let me dig into this. Let me scroll past all the table of contents. Yeah, so sorry for you all that this is around the world, that this is late for you. I'm at 7:45 p.m. my time. But you can catch it later. Here we go. Are you ready? I try to be professional since this is Stephen Avery Project, but sometimes I can't help it and I get bitchy. So, so just know ahead of time when I get mad at some of their crazy bullshit. All right. Issues presented. 1. Did the circuit court erroneously exercise its discretion in denying Stephen A. Avery's June 2017 Wisconsin statute? The state has reorganized and restated the issues to clearly address the only question before the court, whether the circuit court erroneously exercised its discretion when it denied each of Avery's 5 separate motions without a hearing. Avery has presented his claims to this court as if he presented all of his arguments to the circuit court at the same time, and as if the circuit court rejected them all on the merits. That is not what happened. I'm already mad. Yeah, things were submitted at different times because things were being found out at different times. And I don't care. When stuff comes out proving that somebody is innocent, it doesn't matter when it is. You should be able to submit it. Okay, sorry. So, only one paragraph, and I'm already going to be a ranting beast. Okay, back to their bullshit. Avery filed his second section blah motion in June 2017, and the circuit court denied it without a hearing on October 3, 2017. Avery then filed a motion to vacate judgment on October 6, 2017, seeking to vacate the court's order so he could amend his June 2017 motion. Before the court ruled on that motion, Avery filed a motion for reconsideration and 2 supplements to it, raising a host of new arguments. The circuit court denied Avery's motion to vacate judgment and motion for reconsideration in a single order, finding no cause to vacate its judgment and finding the new claims and arguments raised in Avery's motion for reconsideration procedurally barred. Avery filed another motion on July 6, 2018, alleging a Brady violation about the state's examination of the DASI computer. Let's just say Bobby computer. And another on March 11, 2019, alleging a Youngblood violation. These were denied without hearings on September 6, 2018 and August 8, 2019, respectively. And shouldn't we all be raging about that? No hearing. Accordingly, whether the circuit court erroneously exercised its discretion each time when it denied the respective motion in front of it is the only question properly before this court. That question cannot be coherently addressed in the way Avery has organized his brief, with arguments that were raised in different motions and that were denied on different grounds lumped together topically. Further, To the extent that Avery has addressed his separate motions separately, he has done so non-chronologically. The state has therefore reorganized the issues. The Wisconsin Supreme Court abandoned the term, quote, abuse of discretion, unquote, in favor of, quote, erroneous exercise of discretion, unquote, over 2 decades ago. I don't give a fuck. Which was his second section, without holding an evidentiary hearing. The circuit court concluded, yes, this is today's briefing from the state, Laura, and I'm going to be swearing. So earmuffs, or don't have this, don't have the, put on earphones if you're around kids, because just my blood rages when I read anything from these people who have kept Stephen and Brendan in prison for something they didn't do and stolen their lives. So I'm sorry. I got a really nasty mouth. Sorry. The circuit court concluded that Avery's motion was insufficiently pled and that he did not show a sufficient reason for failing to raise these claims on direct appeal or in his first section motion. It further concluded that none of Avery's alleged newly discovered evidence raised a reasonable probability of a different result at a new trial if admitted. This court should affirm the circuit court. 2. Was the circuit court required to allow Avery to pursue his motion piecemeal for any of the following reasons? 1, because the parties had reached an agreement about how Avery would proceed with scientific testing. 2, because Avery planned to supplement his motion but did not alert or seek approval to do so from the court. Or 3, because of the circuit court's 2007 preservation order. All of the above. The circuit court was presented only with the first 2 of these arguments and noted that Avery never requested that the court withhold decision on his section blah blah motion, nor informed the court that he planned to supplement the motion until after a final ruling denying his claims. It determined that Avery could not amend a motion that was filed without reservation, quote, after he receives an adverse ruling, unquote. This court should affirm the circuit court. 3. Did the circuit court erroneously exercise its discretion when it denied Avery's motion for reconsideration and multiple supplements to it without holding an evidentiary hearing? The circuit court noted that Avery mischaracterized as, quote, new evidence, unquote, what were really new claims, and he did not set forth a sufficient reason why these claims could not have been raised in a single section blah motion. Nor did he give a sufficient reason for filing his June 2017 motion when he knew his investigation was complete and that he planned on raising additional claims. It denied the claims raised in the motion and supplements as procedurally barred. This court should affirm the circuit court. 4. Did the circuit court erroneously exercise its discretion in denying without a hearing Avery's motion alleging that the state violated Brady versus Maryland by failing to supply the defense with a CD containing material Detective Michael Velli copied from the Dassey hard drive and Avery's attendant ineffective assistance of counsel claim? Yes. The circuit court found that the state turned over all of the evidence to the defense, and the defense simply failed to assign it any significance and pursue it. Well, if that was true, it's ineffective assistance of counsel. It further determined that Avery's ineffective assistance claim was conclusory and undeveloped. This court should affirm the circuit court. 5. Is your blood boiling? My blood is boiling. I'm really fucking pissed off right now. 5. Did the circuit court erroneously exercise its discretion in denying without a hearing Avery's motion alleging that the state violated Wisconsin statute blah blah and Arizona versus Youngblood by releasing portions of the bone fragments collected in this case to the victim's family? Yeah. The circuit court found that Though the state failed to abide by the notice provisions contained in the statute, it had not violated the substantive subsections, and that the material returned was neither apparently nor potentially exculpatory. Accordingly, Avery failed to allege sufficient facts showing that the state violated either the statute or his constitutional rights. This court should affirm the circuit court. Are you kidding me? You said that the pelvic bones found not at the quarry, which is right next to the salvage yard, but the gravel pit. We don't even know if it's human. We don't even know what it is. Steven Avery never left the salvage yard. Yet you then give those bones to the Halbach family, breaking the chain of custody, not allowing those to be tested. They're supposed to be held as long as Steven is in custody, is in prison. You can't just release evidence. Who's that? 6. Does this court lack jurisdiction to review Avery's motion to compel post-conviction discovery? The circuit court never ruled on this motion. Avery forfeited any complaints about this motion by failing to ask the circuit court to rule on it before filing his appellant brief, which this court lacks jurisdiction to review in any event because there is no written order denying it. Statement on oral argument and publication. The state does not believe that oral argument or publication are warranted. This case involves only the application of well-settled law on the procedural bar and post-conviction pleading standard to the facts, which can be adequately addressed on briefs. Introduction. Avery has embarked upon a significantly different venture than this appeal presents. Andrew, serenity now! He seems to erroneously believe that he's appealing the jury's determination of guilt. He further seems to believe, also erroneously, that if he can identify any conceivable alternate theory of the crime, he has disproven the state's case against him and proven the existence of the constitutional violations he alleged, no matter how insufficiently supportive, speculative, inconsistent, far-fetched, or belatedly raised his argument is. Accordingly, the bulk of his brief is dedicated to relitigating his trial defense, though he cannot seem to settle on any particular theory. But, as he did in the circuit court, Avery has all but ignored the actual issue at the heart of this appeal, the procedural posture of his case. The case is before the Court of Appeal of the Circuit Court's orders denying, without hearings, Avery's 2nd through 6th motions attempting to collaterally attack his conviction. These motions were denied without hearings on the grounds that they were procedurally barred, insufficiently pled, or that the record conclusively demonstrated Avery was due no relief. Accordingly, the question on appeal is not whether Avery is guilty of killing Teresa Halbach. That question was for the jury, which many years ago answered yes beyond a reasonable doubt. Fuck that jury. Fuck Carl Wardsman. And juries aren't given all the evidence, so I don't give a shit what a jury says. Anyway. Nor is the question on appeal whether Avery's latest counsel can construct a different trial defense, find new ways to attack the trial evidence, or identify issues that have not been raised previously. The only question before this court in this appeal is whether any of Avery's motions entitle him to an evidentiary hearing. The answer to that question is no. Though Avery made a litany of allegations across his many motions, 3 critical things were absent from his forest of paper. Oh my gosh, forest of paper. Get fucked. Forest of paper. This is 130 pages. How many forests of paper is this? Sufficient reasons for failing to raise all his post-conviction claims at the same time, sufficient material facts of record to support his allegations, and any developed argument applying the law to explain why the facts of record led to the legal conclusions Avery claimed. It is too well settled for argument that a circuit court has discretion to deny insufficient motions such as Avery's without a hearing. Avery has now glossed over his piecemeal litigation and the deficiencies in his motions by simply re-arguing the merits of his claims in his appellant brief without any reference to how or when he presented them to the circuit court. But on review of a circuit court's decision to deny a post-conviction motion without a hearing, this court looks only to the sufficiency of allegations contained in the four corners of the motion filed in the circuit court, and Avery has fallen far short of showing that any of his motions were sufficient to entitle him to a hearing. Indeed, he has almost entirely failed to address the issue, despite it being his burden and the only issue on appeal. Let me make sure I remind people again, this is not the court. This is the state. So we still now have to wait for the court's response to this. So this is just the state that is always going to be bullshit, that we already know is corrupt. And so that, yeah. So this is just a bunch of more bullshit. So this is the state's response, not the court. Okay, let me go back to all right, so we are now on to page 18 of 130. The circuit court appropriately exercised its discretion in denying each of Avery's motions without a hearing. I mean, just look at that. Without a hearing. What the fuck is the point of our courts if you're not allowed to have a hearing when there's evidence to prove your innocence? Why are the state more concerned with keeping somebody incarcerated as opposed to looking at evidence? This court should affirm the circuit court. Statement of the facts. Pursuant to Wisconsin statute, blah, blah. As respondent, the state opts to omit a statement of the facts. Pertinent facts will be provided in the argument section. Fundamental principles of post-conviction review. A. Criminal defendants are required to raise all post-conviction claims at the same time, absent a sufficient reason for failing to do so. How can you do it all at the same time when this person comes forward at this time? This evidence isn't turned over till that time. You can't do it all at one time. This is ridiculous. Our legal system is so stupid. Quote, we need finality in our litigation, unquote. State versus blah, blah. Accordingly, after the time for a direct appeal has passed, a defendant's ability to attack a conviction or sentence is limited. Jurisdictional or constitutional challenges to a conviction or sentence may be brought pursuant to Wisconsin statute blah blah. But Wisconsin statute blah blah bars successive post-conviction litigation absent a sufficient reason for not raising any issue advanced in a later post-conviction motion on direct appeal or in an earlier motion. Quote, successive and often reformulated claims clog the court system and waste judicial resources, unquote. Keeping people in prison clogs our system that are innocent. Thus, quote, the statutorily mandated review process, unquote, under statute blah blah, requires that all of a defendant's claims for post-conviction relief be, quote, consolidated into one motion or appeal, unquote. Get fucked. 6. In other words, convicted defendants are not entitled to pursue an endless succession of post-conviction remedies. Quote, successive motions and appeals, which all could have been brought at the same time, run counter to the design and purpose of the legislation. Unquote. No, it can't. You can't submit it all at the same time. When Brian said this then, and they hid this CD till then, you can't submit it all at the same time. It's obviously going to be at different times. You have different experts that are looking at the things. Results are coming at different times. B. To warrant a hearing, motions must contain sufficient material facts that would warrant relief, if true, and the record cannot conclusively demonstrate otherwise. Quote, to move beyond the initial prerequisites of Wisconsin statute blah blah, and to adequately raise a claim for relief, a defendant must allege sufficient material facts, e.g. who, what, where, when, why, and how, that if true would entitle the defendant to the relief he seeks, unquote. Conclusory statements that do not contain these key facts are insufficient to entitle the defendant to a hearing. Well, I just read all those who, what, where, why, when. It's in there, idiots. The sufficiency of the allegations in the motion, however, is not the end of the inquiry. Quote, a circuit court has the discretion to deny a defendant's motion, even a properly pled motion, without holding an evidentiary hearing if the record conclusively demonstrates that the defendant is not entitled to relief, unquote. Fuck you. Really? You can deny an evidentiary hearing just because you deem it so. Even though there's evidence, why can't you go over the evidence? Why not? Why wouldn't you go over it? C. Standard of review. Quote, this court will uphold the circuit court's findings of fact unless they are clearly erroneous, unquote. A circuit court's factual findings are clearly erroneous only if they have no support in the record. Whether claims are barred by Wisconsin statute blah blah is a question of law this court reviews de novo. Likewise, quote, whether a defendant's post-conviction motion on its face alleges facts which would entitle the defendant to relief, and whether the record conclusively demonstrates that the defendant is entitled to no relief are questions of law that an appellate court reviews de novo, unquote. This court reviews, quote, only the allegations contained in the four corners of the defendant's motion and not any additional allegations that are contained in the defendant's brief, unquote. If the defendant's motion fails to adequately allege a sufficient reason to overcome blah blah, does not contain the requisite material facts, quote, presents only conclusory allegations, or if the record conclusively demonstrates that the defendant is not entitled to relief, unquote, then this court reviews the circuit court's decision to grant or deny a hearing, quote, under the differential erroneous exercise of discretion standard, unquote. Quote, a court exercises discretion when it considers the facts of record and reasons its way to a rational, legally sound conclusion, unquote. Quote, the court's discretionary determinations are not tested by some subjective standard or even by, and hold on, let me post the link to this again in here for people who want to read it themselves. Where was I? Okay. Quote, the court's discretionary determinations are not tested by some subjective standard or even by this court's own sense of what might be a right or wrong decision in the case, but rather will stand unless it can be said that no reasonable judge in Stephen's case, acting on the same facts and underlying law, could reach the same conclusion, unquote. Additionally, quote, it is well established that if a trial court reaches the proper result for the wrong reason, it will be affirmed, unquote. Argument 1. The Circuit Court properly denied Avery's June 7, 2017 motion without holding an evidentiary hearing. Allegations in Avery's June 2017 motion. As relevant here, Avery raised the following claims in his June 27, 2017 section blah blah motion. 1. Avery's trial attorneys, Dean Strang and Jerome Buting, were ineffective for failing to obtain 6 additional expert witnesses in blood spatter patterns, trace evidence examination, forensic anthropology, burned remains, DNA testing, and police procedure. 2. Trial counsels were ineffective for failing to conduct various experiments. And when I do this, it's because they have the word in quotes. 3. That only one person, Ryan Hilgas, quote, meets the requirements of Denny as a third-party suspect, unquote. And then in the footnote, it says, Avery raised several claims in each of his motions that he has not pursued on appeal. By failing to brief those issues, Avery has abandoned them, and the state will not discuss them further. Avery relied on other experts in this motion, but either never failed any argument that Strang and Buting were ineffective for failing to hire them, or has failed to pursue that argument on appeal. 4. Quote, trial defense counsel failed to properly investigate a variety of topics, unquote, about several evidentiary items. 5. The state withheld, in violation of Brady, 1. A CD of a voicemail Teresa Halbach left on the Zipper family's answering machine the day of her murder, stating that Ms. Halbach was having trouble finding their house. 2. Unedited flyover video from an air search of the Avery property. And 3. Investigators' purported knowledge that Teresa Halbach's Toyota RAV4 was driven onto Joshua Rodant's property because Rodant provided an affidavit stating that some unknown person from the Department of Justice told him they believed the RAV4 was driven onto the Avery property. 6. That Avery had newly discovered evidence establishing that one of the damaged bullets introduced at trial was not shot through the victim's skull. 2. Avery's DNA on the RAV4 hood latch was planted. And 3. Avery's DNA on the key to the RAV4 was planted. Avery alleged that his sufficient reason for failing to raise these claims on direct appeal was ineffective assistance of post-conviction counsel. Avery further alleged that his sufficient reason for failing to raise all of these claims in his 2013 pro se section blah blah motion was that he, quote, had no way of knowing, unquote, about his claims because he was a, quote, learning disabled indigent prisoner, unquote. Yeah, that's true. The Circuit Court's order denying the motion. On October 3, 2017, the Circuit Court denied the motion without an evidentiary hearing. The court determined Avery had not shown a sufficient reason why these issues could not have been raised in his 2013 motion or other prior post-conviction litigation. It further found that Avery's arguments stemming from his new experts' reports omitted several significant facts showing that the results of the testing did not show what Avery claimed they did, and that he relied mainly on conclusory allegations. Accordingly, it found Avery had not met his burden to show that there was a reasonable probability of a different result at a new trial where these results were admitted. A. Avery failed to show a sufficient reason for failing to raise his June 2017 claims in his February 2013 motion or on direct appeal, so they are procedurally barred. Avery's June 2017 motion was his third attempt at post-conviction relief. For the court to reach the merits of his allegations, then Avery had to overcome blah blah twice. He had to adequately plead a sufficient reason for failing to raise his June 2017 claims in his Wisconsin statute motion and his 2013 section blah blah motion. Avery showed neither, so the circuit court properly exercised its discretion in denying his motion without a hearing. Is your blood boiling? 1. Avery's conclusory allegation that he did not raise these claims in his 2013 motion because he is indigent and has no legal training was not a sufficient reason. Avery failed to properly plead a sufficient reason for not raising his 2017 claims in his 2013 motion, and therefore this court need go no further to determine that the circuit court properly denied his June 2017 motion without a hearing. Avery devoted a mere 2 paragraphs of his 200-plus page motion to alleging a reason for failing to raise his claims in his 2013 motion. The sole reason his claims in his 2013 motion. Oh, I said that already. The sole reason Avery offered was a conclusory statement that he had a, quote, lack of legal knowledge, unquote, and unspecified, quote, cognitive deficiencies, unquote. You got to remember, Stephen's IQ is less than Brendan's. And claimed he therefore, quote, had no way of knowing the factual and legal basis the claims set forth herein. As a learning disabled indigent prisoner, Mr. Avery could not have known them, unquote. Yeah, fact. The only facts he supplied about this claim were that his current attorneys had spent a lot of time and money preparing the motion. Avery's allegation was factually and legally insufficient. Yeah, because he's not a fucking lawyer. So Tim Murray, go fuck yourself. All right, so let's get back into this. First, assuming that cognitive difficulties and a lack of factual and legal knowledge could have been a sufficient reason, Avery failed to allege sufficient material facts to support his assertion. To be sufficient, defendant's reason for failing to raise claims previously must be supported by more than conclusory allegations. Avery claimed that, quote, numerous unique circumstances are present here that provide sufficient reasons the current claims were not previously presented, unquote. But he did not attempt to explain what those circumstances are. He did not explain why the circumstances are unique, why or how they precluded Avery from knowing about his claims, what legal or factual knowledge was required that Avery lacked, particularly in light of his many pro se filings setting forth relevant law in discussing his case, what Avery's, quote, cognitive deficiencies, unquote, are, or how they prevented him from knowing about and raising his claims, or why current counsel's decision to spend vast sums of money meant that Avery was unaware of his claims previously. Avery's claim that he had no way to know the, quote, factual basis, unquote, for his claims was particularly insufficient. It amounted to a bare passing mention of the term, quote, factual basis, unquote. Oh, Tim, bless your heart. In other words, Avery provided no, quote, facts that allowed the reviewing court to meaningfully assess, unquote, his reason. The circuit court was well within its discretionary authority to deny the motion without a hearing or failing to overcome the procedural bar. Avery's allegation was insufficient for a second reason. Tammy, I need to send this to you so you can, Tammy, can, here's the link again that I'm going to post here in this thing. Since you're on, Tammy Coling, who just came on here, she's my boss at WMP Justice Review. And so this woman knows so much about our legal system. It is insane. So, Tammy, I'm reading through this now. I mean, I'm on page 26 of 130. You can follow along with what I'm reading, but you can also just read it yourself. And Tammy, maybe you and I could go live tomorrow at some point, and you can explain it to me. And explain it to everybody. You know, put it in a way we can all understand. Oh, is this Monica now taking a shot at me with my Yeah, I a lot. Yeah, Tammy, you my boss. I'm just not paid. All right. Let me go back to where I was. Oh, here I am. Some more. Where was I? Avery's allegation was insufficient for a second reason. While a lack of knowledge of the factual basis for a claim may be a sufficient reason, it has long been recognized that a defendant's pro se status or lack of legal knowledge is not. Nearly all collateral attacks are raised by pro se prisoners, many of whom have intellectual challenges and very few of whom are lawyers. While the Wisconsin courts liberally construe pro se prisoners' filings, Tim's still going. Prisoners are still expected to properly raise claims for relief, including sufficiently overcoming the procedural bar. None of the cases Avery cited support his claim that lack of legal knowledge, indigency, or pro se status is a sufficient reason. Avery misrepresented or misread them all. In Aaron Allen, the court rejected the defendant's claim that his unawareness of the factual basis for his claims was a sufficient reason because the record showed that the claims, quote, involved events in which Allen was personally involved and had personal knowledge, unquote. That has nothing to do with the defendant's, quote, unawareness of the legal basis of his claim, unquote. And Aaron Allen establishes that lack of knowledge of the, quote, factual basis, unquote, for a claim does not mean what Avery appears to think it means. Lack of knowledge of the factual basis for a claim means an event occurred that supported a claim and the defendant had no way of knowing about the event. It does not mean that the defendant simply did not know what facts an attorney might use to argue the claim. Avery knew all about the facts of his case. Also, in Aaron Allen, the court rejected Avery's precise argument that State versus Howard established the lack of legal sophistication as a sufficient reason. Howard established that lack of knowledge of the legal basis of the claim may be a sufficient reason, quote, where a subsequent Supreme Court decision constituted a new rule of constitutional law, unquote. Like in Allen, Howard is a posit here, quote, there is no question that Strickland versus Washington, unquote, and Brady were, quote, established law at the time, unquote. Avery filed his 2013 section blah blah motion. Blah blah. Blah blah does not stand for the proposition that lack of legal knowledge due to pro se status is a sufficient reason either. In Kyles, the defendant was denied counsel during a critical stage of the proceeding. The Supreme Court determined that his Knight petition was not procedurally barred by his previous attempts to reinstate his direct appeal. And now I'm forgetting the word again. The thing at the bottom of the page. I keep wanting to say postscript. Neither paragraph Avery cites for his proposition even arguably supports that statement. Paragraph 44 is the court's rejection of Allen's allegation that Howard supported his claim. Paragraph 81 is not a statement of any legal principle, but a quote from this court about whether the Anders procedure was followed in Allen's case. Sassy. Tammy, how long does the state have, the court have to respond to the court's response? All right. So, but that was because the court found it, quote, incongruous to state that a defendant was denied the right to counsel and then preclude the defendant from raising a claim because of errors made due to the absence of counsel, unquote. There is no right to counsel on collateral attack. So Avery cannot plausibly argue that Kyle's established that pro se status is a sufficient reason for failing to raise a claim in an earlier section blah blah motion where he had no right to counsel. Neither this court nor the Wisconsin Supreme Court has ever construed Kyle's in the manner Avery suggests. 2. Avery has not shown that his motion was sufficiently pled. Avery has failed to show that his June 2017 motion's 2 conclusory paragraphs about his 2013... Somebody's messaging me. Sorry, it's a moderator. Okay. Moderator dealing with something. Sorry. Where was I? Avery claims in his brief that he, quote, has met all of the Allen requirements, unquote, for his claims, but he has misunderstood the pleading standard. Avery directs this court only to where he purportedly met those requirements in his appellate brief. To be entitled to a hearing, Avery had to meet those requirements in his motion to the circuit court. He cannot cure the deficiencies in his motions in his appellate brief. Avery complains that the circuit court, quote, did not analyze whether these collective circumstances constituted a sufficient reason, unquote, but he's made no showing that he pled sufficient facts for the court to analyze. And then it says, Avery has made the same error in regard to all of his claims, not just the claims he raised in his June 2017 motion. The court noted that Avery claimed that his pro se motion, quote, should not preclude his June 2017 motion from being heard, unquote. But the court found, quote, there is no argument or showing of a sufficient reason why these issues could not have been raised in prior motions, unquote. Avery simply stating he was incapable of raising the claims is not a factually supported argument explaining why not, and the circuit court was not required to develop it for him. Furthermore, Avery's assertion that he was incapable of recognizing and raising legal claims was demonstrably false. The circuit court remarked that Avery's pro se motion, quote, recognized sufficient or significant legal issues with the court previously ruled on, unquote. These issues included ineffective assistance of trial and post-conviction counsel. And let me pause here and thank the Stephen Avery Project moderators. That's who I'm getting messages from that are trying to deal with the stuff that you guys have on there. So thank you so much to the moderators because they're doing stuff I can't do. So Tom Davies is talking about when I say blah, blah. When I say blah, blah, it's because they're referring to numbers and such of a statute. That is it imperative that you know the number of whatever statute they're citing? So do you want me to read a 13-digit number? It doesn't matter. So that's what the blah, blah says. Statute number blah, blah. Statute blah, blah. That's all I'm saying. It doesn't matter. So you want the specific statutes? I've posted the link to this a million times. Go read it yourself and pull out the statute. There you go. Those issues included ineffective assistance of trial and post-conviction counsel. The fact that the court rejected these claims does not mean that Avery was incapable of raising legal claims as Avery appears to believe. Avery, footnote. I'm going to the word just popped up to me. I am going to write it down because I keep forgetting the frickin' word when I go to read the things that are at the bottom of the page. Avery now attempts to bolster his motion by asserting that his reason is insufficient because he, quote, wrote to dozens of attorneys, unquote, and, quote, wrote to laboratories that would not respond unless he had an attorney, unquote. Avery did not make these assertions in his June 2017 motion, and therefore they are irrelevant to evaluating whether the circuit court properly denied the motion it had before it. Regardless, these allegations refute Avery's assertion. Obviously, if Avery contacted attorneys and laboratories in an attempt to raise these issues, he knew that they were available to be raised. Wrong. And the footnote is Avery alleged this in his affidavit, but exhibits do not relieve a defendant of alleging the pertinent facts in the motion. See State v. Love, 2005, Wisconsin, 116-27-284, Wisconsin, 2D, 111-700, NW 2D62. So would you rather I read that and then just say blah, blah? Anyway. The facts to support a claim must be alleged, quote, within the four corners of the document itself, unquote. Contacted attorneys and laboratories in an attempt to raise these... Oh, I read that part already. Sorry. Otherwise, Avery simply reiterates that he told the circuit court that he lacked the legal sophistication to raise the claims, quotes his own section, blah, blah, motion, as legal authority, and directs his court to the same in apposite case law he cited below. None of that shows that he sufficiently pled his motion. In short, Avery's bare-bones assertion in his June 2017 motion was not enough to allow the circuit court to meaningfully evaluate his alleged reason for failing to raise his June 2017 claims in his 2013 motion. So the court found that he had not shown a sufficient reason. That was a reasonable evaluation of Avery's motion, and he had failed to show otherwise. The circuit court properly exercised its discretion in denying Avery's June 2017 motion without a hearing. I'm still waiting for, and I said again, drink, Kathleen's October 2019 filing. They're going into 2013 and 2017 over and over again. 3. Avery's allegation that post-conviction counsels were ineffective was insufficiently pled and meritless. Even if the court overlooks Avery's failure to show a sufficient reason for failing to raise his current claims in his 2013 motion, it should still affirm the circuit court. Avery failed to sufficiently show that either trial or post-conviction counsel were ineffective. Although the circuit court was wrong about the law on post-conviction procedure, the record shows that it still reached the right conclusion, and accordingly, this court must affirm its decision to deny this motion without a hearing. The footnote says, defendants unawareness of the factual and or legal basis for his claims may constitute a sufficient reason for his failure to raise those claims, unquote, in quotation marks, with a citation to his June 2017 section blah blah motion. A. Law governing ineffective assistance of counsel. Quote, Wisconsin criminal defendants are guaranteed the right to the effective assistance of counsel through the 6th and 14th Amendment to the federal Constitution and Article 1, Section 7 of the Wisconsin Constitution. Unquote. Ineffective assistance claims are evaluated using the two-pronged test set forth in Strickland v. Washington. To prevail under Strickland, a defendant must prove that his counsel's performance was both deficient and prejudicial. Quote, the defendant does not show the first element simply by demonstrating that his counsel was imperfect or less than ideal, unquote. Quote, to prove deficient performance, a defendant must show specific acts or omissions of counsel that are outside the wide range of professionally competent assistance, unquote. Counsel's decisions based on a reasonably sound strategy are, quote, virtually unchallengeable, unquote, and do not constitute deficient performance. Quote, the defendant must not presume the second element, prejudice to the defense, simply because certain decisions or actions of counsel were made in error, unquote. To prove prejudice, quote, the defendant must show that counsel's deficient performance actually had an adverse effect on the defense, unquote. Further, the defendant must do more than, quote, show that his counsel's errors had some conceivable effect on the outcome of the proceeding, unquote. The defendant must show that, quote, there is a reasonable probability that but for counsel's unprofessional errors, the result of the proceeding would have been different, unquote. B. Avery did not show that post-conviction counsels were ineffective. 1. Law governing ineffective assistance of post-conviction counsel as a sufficient reason. Avery claimed that his sufficient reason for failing to raise on direct appeal his ineffective assistance of trial counsel claims regarding hiring experts, performing experiments, and attempting to pin the crime on Ryan Hilgas, along with Brady claims regarding the zipper voicemail, the flyover video, and Radant's allegations, was that his post-conviction counsel, Suzanne Hagopian and Martha Askins, were ineffective. Ineffective assistance of post-conviction counsel may constitute a sufficient reason for failing to include claims in earlier motions. To overcome the procedural bar on that ground, though, the defendant must allege sufficient facts that are supported by the record and would show that the post-conviction counsel's failure to raise the claim was both deficient and prejudicial. If the defendant makes, quote, a mere conclusory allegation that his post-conviction counsel was ineffective, ... his reason is not sufficient, unquote. And then the footnote says Avery has falsely represented that he raised his Brady claims regarding Denise Heidel, Kevin Romlo, and Detective Veli CD in his second motion pursuant to Wisconsin statutes blah blah, and implies that the circuit court denied them in its October 3, 2017 order. These claims were raised in Avery's October 23 through November 17, 2017 motion for reconsideration and his July 2018 section blah blah motion, and denied in subsequent orders. The state addresses whether the circuit court properly rejected these claims in issues 3 and 4 and will not address them here. Additionally, quote, a defendant who alleges in a blah motion that his post-conviction counsel was ineffective for failing to bring certain viable claims must demonstrate that the claims he wishes to bring are clearly stronger than the claims post-conviction counsel actually brought, unquote. Quote, this standard is difficult to meet because the comparative strength of two claims is usually debatable, unquote. 2. Avery's allegations about post-conviction counsels were conclusory and meritless. The state does not dispute that the circuit court confused the procedure for raising ineffective assistance of post-conviction counsel with the procedure for raising ineffective assistance of appellate counsel when rejecting this claim. However, whether a section blah motion adequately pleads a sufficient reason for failing to bring available claims is a question of law review de novo. And this court will affirm if the circuit court reached the right result for the wrong reason. And here, the record shows that the circuit court still properly denied Avery's motion. Avery's motion, quote, was conclusory because it failed to carefully address the two elements of ineffective assistance for post-conviction counsel set out in Strickland, and the motion generally ignored the 5 W's and 1 H methodology outlined in John Allen, unquote. Hagopian and Askins raised 4 issues on Avery's direct appeal. 1. The court had improperly barred Avery from admitting third-party perpetrator evidence. 2. Multiple searches had violated Avery's Fourth Amendment rights. 3. The trial court had improperly excused a deliberating juror. And 4. Trial counsels were ineffective for acquiescing to the dismissal. Avery stated that post-conviction counsels were ineffective, quote, because they failed to argue that Mr. Avery's trial defense counsel was ineffective as described, unquote, in his June 2017 motion. He then claimed that, quote, ineffective assistance of trial counsel was clearly stronger than the issues raised in their blah motion. Avery recited how the post-conviction court ruled on the third-party perpetrator claim and reiterated his alternate theory of events constructed with his new expert and, quote, experiments, unquote. He then stated that Hagopian and Askins should have raised these ineffective assistance and Brady claims, should have learned this alternate theory of events from Avery, and declared post-conviction counsel ineffective. Though Avery cited to cases about ineffective assistance in his June 2017 motion, he failed to apply that law to the facts and explain how or why Hagopian's and Askins' failure to raise his new claims was objectively unreasonable, and that there was a reasonable probability of a different result if they had. His motion was insufficient on multiple fronts, and accordingly, Avery failed to overcome the procedural bar. I am now moving on to page 34 of 130. I. Avery's claims about the Zipper CD, Rodant's alleged conversation, and the flyover video were insufficiently pled. Avery's bold allegation that Hagopian and Askins should have raised the Brady claims is facially insufficient because it simply concludes that failure to do so was deficient and prejudicial without providing any facts or developing any argument. Avery made no attempt to show why it was unreasonable not to raise these claims, provided no evaluation of the comparative strength of these claims to the claims post-conviction counsels raised, and made no attempt to show that there was a reasonable probability of a different result. The underlying claims were insufficiently pled as well. Avery's allegation that Rodant supposedly spoke with some unidentified, it's not Avery's allegation. Rodant says this. So Rodant said that he spoke with some unidentified DOJ personnel, fails to provide any material facts about this claim. Avery does not say who Rodant had this conversation with, when it occurred, what the context was, and what this person's belief was based on, or why Rodant did not tell trial counsel or anyone else about it in the 12 years between trial and his affidavit. Further, Avery did not provide any facts to establish that it would be material. He said only that, quote, this information could, meaning words have been removed, have been used to impeach the state's witnesses, unquote. With nothing about who it would have impeached or why that would raise a reasonable probability of a different result at trial, considering the rest of the evidence. Avery further claimed Radon's testimony, quote, would have provided exculpatory evidence, that the RAV4 was planted on his property, unquote. But Avery failed to plead any facts establishing this either, because he alleged no facts about when this conversation took place, who said it, and why, when, or from where the believed the RAV4 was driven onto Avery's property. Oh, so much to say. An unidentified DOJ employee purportedly saying they believed the RAV4 was driven onto the Avery property at some unidentified time fails to establish that it was driven onto the property after the murder or by someone other than Avery. Avery has made no attempt to appeal to show that his motion was sufficiently pled on this claim, either as a standalone claim or on his allegation that post-conviction counsels were ineffective, and simply re-argues the Brady claim. But again, the merits of this claim are not before this court. The issue is whether Avery sufficiently pled that Hagopian and Askins were ineffective for failing to raise it. By failing to address the issue on appeal, Avery has failed to meet his burden. Similarly, Avery's claim that the flyover video was edited was utterly devoid of facts and relied wholly on Avery's speculation that more footage must have existed because the prosecutor said the RAV4 was not visible on the video and the flyover produced only 3 minutes of footage. And Avery has again failed to show, my temperature's rising right now, sorry. And Avery has again failed to show that his motion was sufficiently pled either as a claim against post-conviction counsel or on his Brady claim, and simply re-argued the Brady claim, but still provided nothing more than his unsupported speculation that the video was edited. He then asked the court to authorize an impermissible fishing expedition, stating that, quote, an evidentiary hearing is necessary to determine the credibility of the state's claim that only 3 minutes of flyover footage exists, unquote. Sorry, just got an email. An evidentiary hearing is a forum to prove factually supported claims, not a fishing expedition to discover them. Post-conviction counsels were not ineffective for failing to raise a claim based on nothing. How many hours was Wendy Baldwin and who was the other one that was in the plane? How many hours were they flying? And there's only 3 minutes of video? You don't have to be a genius to go, you're not giving the whole video. Somebody remind me of how many hours they were flying. I don't recall numbers. I have a really bad thing with numbers. But I know we just went over it in Kathleen's briefing. Hours, multiple hours that they were flying. But there's only 3 minutes of video. Who's that? There you go, Melissa. Avery's Brady claim about the message the victim left on the zipper's answering machine was insufficiently pled to because Avery failed to establish that the message was suppressed, exculpatory, or material. Avery did not provide anything from Strang and Buting showing this was not turned over to the defense, and simply declared it wasn't because the state can't locate it now. Yeah, Lynn, like 3 or 4. Yeah. That shows nothing. Avery then mused that the 2:12 p.m. voicemail Teresa Halbach left on the Zippers answering machine about having trouble finding their house must have been exculpatory because the prosecution failed to play it for the jury. That is nothing more than speculation. So why is that gone? Why is the 3 or 4 hours of flyover video gone? Why is that voicemail message gone? Not speculation. Besides, Joellen Zipperer testified at trial and said Teresa Halbach was at their house around 3, and that Joellen heard the message later that evening but had missed the call because she was outside. Oh, so when Joellen Zipperer says something, let's just believe it. But when Joshua Radant says, DOJ says that somebody drove through his property to go through the back end to plant the car at Avery Salvage, oh, there's no proof to that. Nothing about Halbach leaving a voicemail at 2:12 p.m. stating that she can't find the Zipperer's house, but then later arriving does anything to, quote, contradict the timeline established by the state, unquote. And Avery still provides only speculation about this claim. He again just says the voicemail, quote, may have contradicted the timeline established by the state, unquote, that Ms. Halbach's last stop was Avery's. He fails to explain how, though. The claim was and is insufficiently pled. Well, if you listen to the original police recordings, they state as fact that Zippers was the last stop. So, 2. Avery's claims about ineffective assistance of trial counsel were insufficiently pled and conclusively refuted by the record. That leaves Avery's claim that Hagopian and Askins were ineffective for failing to claim Strang and Buting were ineffective for failing to pursue and present the retooled planted evidence defense he created in his June 2017 motion, alleging that the killer planted the blood evidence and the victim's remains and effects, and relying on a multitude of experts to conduct experiments about the trial evidence. Yeah, imagine that. Relying on experts. That's weird. Really? Why would somebody do that? In a nutshell, Avery argued in his June 2017 motion that Strang and Buting were ineffective because Avery believes he could have prevailed at trial if Strang and Buting had presented his planted evidence defense in the manner current post-conviction counsel formulated. Saying Kathleen formulated it makes it out like she made it up. No, it's going off of evidence and facts and experts. Real experts, not somebody who is told to put her in the house, the trailer garage. Therefore, he concluded Hagopian and Askins must also have been ineffective for failing to allege that Strang and Buting were ineffective on that ground. That is a fundamental misunderstanding of what is required to show ineffective assistance of counsel, trial, or post-conviction. Avery's simply alleging that Strang and Buting could have presented a planted evidence defense differently by hiring experts performing experiments of dubious reliability and claiming that the blood evidence was planted by, quote, the killer, unquote, and not law enforcement, does not provide anything that would establish Strang and Buting were ineffective, even if the facts Avery alleged were true. Yeah, it does. Strang and Buting not hiring their own experts to find all of this stuff way back then is ineffective assistance of counsel. Point blank, and the period. Quote, an accused cannot follow one course of strategy at the time of trial, and if that turns out to be unsatisfactory, complain he should be discharged or have a new trial, unquote. Quote, to permit post-conviction counsel to argue for a different game plan after the contest is over would be Monday morning quarterbacking, unquote. After all, there are, quote, countless ways to provide effective assistance in any given case, unquote. And, quote, counsel is entitled to formulate a strategy that was reasonable at the time and to balance limited resources in accord with effective trial tactics and strategies, unquote. Neither a disappointed defendant, nor a court may, quote, second guess counsel's performance slowly because the defense proved unsuccessful, unquote. Second guessing supported by speculation is all Avery provided. Though either in his motion or his brief, Avery has simply taken the trial record and, working backwards, quote, stressed what current post-conviction counsel would have done differently had she conducted the defense at the time of trial, unquote. But it has long been settled that, quote, it is the considered judgment of trial counsel that makes the selection among available defenses, not the retroactive conclusion of post-conviction counsel, unquote. And that a court must not evaluate counsel's performance based on hindsight like Avery has done here. Rather, to show deficient performance, a defendant must show that counsel's acts or omissions were objectively unreasonable from counsel's perspective at the time. That is, counsel's decisions were outside the boundaries, quote, of reasonable professional judgment, unquote, under the circumstances. So, Avery had to show that, from Strang and Buting's perspective, before trial and balancing limited resources, it was objectively unreasonable for Strang and Buting not to consult and present this bevy of experts and experiments, not to construct this alternate theory of events alleging that Ryan Hilgus abducted and killed the victim and then planted the RAV4, the blood evidence, and the victim's remains and personal effects to frame Avery, and not to present that defense instead of the one they chose. He also had to show there was a reasonable probability that the jury would have acquitted him if they did those things. And the footnote says, Avery's kitchen sink approach to the issues on appeal, unquote, has left the state unable to discern what defense he is actually alleging Strang and Buting were ineffective for failing to present. Because there was so much wrong with that. That's why. Oh, the kitchen sink, they're throwing everything at it because there are so many things wrong in his original case. That's why. And despite Avery's laundry list of Strang and Buting's alleged failures, Avery alleged no material facts of record that would establish that Strickland required them to do any of this, or that Avery was prejudiced by these alleged failures. His ineffective assistance of trial counsel claims were insufficiently pled, so his ineffective assistance of post-conviction counsel claim was as well. Quote, to establish that post-conviction or appellate counsel was ineffective, a defendant bears the burden of proving that trial counsel's performance was deficient and prejudicial, unquote, as well. A. Several of Avery's claims about trial counsel are misframed inappropriately raised or not argued in his brief. Several of Avery's claims in his brief on this point do not warrant discussion because they are misframed, insufficiently developed, or forfeited by his failure to raise them in trial court. Avery's single sentence that he, quote, described in his June 2017 motion a variety of failures of trial defense counsel to conduct a significant investigation before trial, unquote, is devoid of any facts or argument that the circuit court erroneously exercised its discretion or even any explanation what failures he is discussing. And the footnote says, claimed in his June 2017 motion was that Ryan Hilgas was the only person who could have committed the crime and that Strang and Buting were ineffective for failing to present this theory. As that is what was presented to the circuit court when it denied this motion, that is what the state will discuss here. Whether Avery's later motions alleging other theories were properly denied will be discussed in later sections. Similarly, Avery never mentions hiring a police procedure or forensic pathology expert in his appellate brief until his summary sentence on this point. Though he references experts in these subjects later in his brief, he provides no developed argument about why Strang and Buting were ineffective for failing to hire them. Further, no Wisconsin case has ever found that a police procedure expert is admissible. Given the high likelihood of such testimony devolving into a mini trial about the propriety and protocols of the police department, a police procedure expert would be excluded under Wisconsin statute blah for causing confusion of the issues, undue delay, and waste of time. Quote, it is insufficient to just state an issue on appeal without providing support for the position and providing legal authority supporting the position, unquote. And issues raised in the trial court but not argued on appeal are deemed abandoned. Avery's conclusory allegations on these claims are insufficient to warrant consideration. Indeed, they are insufficient to even allow the state to formulate a response. Avery did not provide any argument on these points, and the state is not required to develop them for him in order to refute them. These claims are abandoned. They don't have the unquote, so... Oh, we have another idiot. Sorry. Where was I? Okay. In Avery's June 2017 motion, he claimed that Dr. Christopher Palanik's examination of bullet fragment, the magic bullet, and ballistics experts Lucian Haig's conclusions about the magic bullet were newly discovered evidence. Avery never alleged that Strang and Buting were ineffective for failing to hire Haig or for failing to have Palanik conduct a trace evidence examination of the magic bullet, as he now claims. Avery's claim that he hired an audio expert also appeared nowhere in his motions to the trial court and is insufficiently developed to warrant discussion. In Avery's motion, he simply declared what the audio clip supposedly said in a single sentence. Avery failed to even identify who this supposed audio expert is or what enhancement they allegedly did, let alone argue anything related to sufficiency of his motion or the two prongs of Strickland on this point. Avery cannot show that the circuit court erroneously exercised its discretion by presenting arguments on appeal that he did not present to the circuit court. These claims are forfeited. Issues not raised in the trial court will not be considered for the first time on appeal. And the footnote says, The Wisconsin Supreme Court in State versus blah blah discussed the difference between waiver and forfeiture and recognized that this rule is more consistent with the concept of forfeiture than waiver. Later, in Avery's brief, he claims that Strang and Buting, quote, could have hired a forensic pathologist, unquote, Dr. Larry Blum, to opine that the scratches on Bobby Dassey's back are inconsistent with a dog's paw, but this claim was never raised in the circuit court and certainly not in Avery's June 2017 motion. Avery simply offered Blum's opinion in his July 6, 2018 motion. Yeah, see? Because didn't know. Even if that were construed as an ineffective assistance claim, the circuit court denied Avery's ineffective assistance claims raised in that motion as insufficiently pled, which is supported by the record. Avery's ineffective assistance claim in that motion was a final catch-all paragraph stating that if the court rejected his Brady claims, it should find counsel ineffective without developing any argument on the issue. There is no question the circuit court properly denied that allegation without a hearing. I question. Adam, this is today's response, state's response, so this is new that I'm reading off the internet. Additionally, all of Avery's claims that Strang and Buting were ineffective for their, quote, failure to investigate and impeach, unquote, Bobby Dassey were not raised until Avery's October 23 motion for reconsideration. The circuit court denied the claims in Avery's motion for reconsideration as procedurally barred because Avery did not offer a sufficient reason for failing to raise these arguments in his June 2017 motion. Oh my God. So he has to, sorry, I'm going to go way off course there. I just need to keep reading this. The circuit court denied the claims. Avery has inappropriately re-argued those claims here in an effort to overleap the procedural bar without making any argument that he showed a sufficient reason for failing to raise these claims in his June 2017 motion. This court should decline to address these claims. The state will address whether Avery's motion for reconsideration was sufficiently pled in Section 3 of this brief. And now we are going on to page 43 of 130. B. Avery's remaining ineffective assistance of trial counsel claims did not warrant a hearing. The ineffective assistance claims Avery both actually raised in his June 2017 motion and has provided argument about in his appellate brief did not warrant a hearing. Avery claims Strang and Buting were ineffective for failing to hire a blood spatter expert, Stuart James, trace evidence expert, Christopher Palahniuk, to determine whether the RAV4 key found in Avery's house was a subkey. No, that's a fact. It's a subkey. DNA expert, Carl Reich, to test how much DNA a person leaves on a hood latch by touch, and forensic anthropologist Stephen Symes. He further claims Strang and Buting were ineffective for failing to conduct various experiments themselves, failing to discover that Avery's blood in the RAV4 did not come from the vial of his blood located in the Manitowoc County Clerk of Circuit Court's office, failing to investigate Avery's claim that his blood from his bleeding finger was removed from the sink by the real killer, who then planted the blood evidence in the RAV4. And failing to establish Ryan Hilgas as a Denny suspect. Avery did not provide sufficient material facts in his motion that would show counsels were ineffective for failing to do any of these things. And now this has it in italics. Counsels were not ineffective for failing to hire more experts and perform experiments. Quote, Strickland does not enact Newton's third law for the presentation of evidence, requiring for every prosecution expert an equal and opposite expert from the defense, unquote. And the footnote says Avery claimed Palahniuk and Reich's other tests were newly discovered evidence, which is addressed in section IB. Quote, in many instances, cross-examination will be sufficient to expose defects in an expert's presentation. When defense counsel does not have a solid case, the best strategy can be to say that there is too much doubt about the state's theory for a jury to convict, unquote. And here, Avery did not show that Strickland required Strang and Buting to call these experts or perform these experiments, or that there was a reasonable probability or a different result if they had. Cross-examination and the experts they did call effectively established Avery's defense, and Avery's new experiments proved nothing. As a preliminary matter, unlike Avery's other ineffective assistance claims, the circuit court addressed the merits of Avery's claims that Strang and Buting were ineffective for failing to present Reich's experiments about the quantity of DNA left on the hood latch, and Palahniuk's conclusions about the key being a subkey. The circuit court discussed them in the portion of its order, concluding that there was not a reasonable probability of a different result at trial if Avery's DNA testing related experiments were admitted. To avoid duplication and clearly address the reasons the court gave for denying Avery's motion, the state addresses these arguments in section IB. That leaves Avery's claims that Strang and Buting were ineffective for failing to hire blood spatter expert Stuart James, forensic anthropologist Stephen Symes, and for failing to conduct various experiments themselves. I don't believe that Kathleen's filing or anybody's filing is saying that Strang and Buting had to hire the experts that Kathleen has now. It's just saying they should have gotten experts. First, Avery has again failed to argue on appeal that his motion was sufficiently pled to warrant a hearing on these claims and merely re-argues their merits. Because Avery has failed to address the issue on appeal, he has failed to meet his burden. Nevertheless, nothing he alleged in his motion met the pleading standard anyway, either because Avery's allegations were conclusory or because the record conclusively demonstrated that he was due no relief, or both. Avery's blood spatter expert, James, far from quote, demonstrated that Mr. Avery's blood was planted in Ms. Halbach's RAV4, unquote. For this proposition, Avery relied on an experiment conducted by James in which blood was dripped from James' middle finger, and he left blood in a test RAV4 in several more places than where Avery's blood was found in Ms. Halbach's RAV4. Avery then concluded that he proved the blood in Ms. Halbach's RAV4 was planted by being selectively dripped and applied with an applicator because James was able to construct similar blood stains to those in Ms. Halbach's RAV4 by that method. Yeah, that totally sounds reasonable to me. Imagine that, doing actual tests. Avery further asserted that he proved that the blood flakes found on Ms. Halbach's RAV4 were scraped off of Avery's sink and planted because when James dripped blood on the floor of a RAV4, it soaked into the carpet, and James was able to create blood flakes by scraping dried blood off of a sink with a scalpel. None of that proves anything. Actually, it does. James being able to recreate something by a particular method doesn't show that no other method was possible. Well, yeah, it's showing that if your finger is dripping blood, as they're stating, it wouldn't just create blood flakes on the carpeting. There would have to be blood in the carpet. And James never opines that. Quote, the most likely source, unquote, of the blood in the RAV4. Somebody just sent me this. Sorry. Of the blood in the RAV4 was the blood in Avery's sink, unquote, as Avery claims. James' affidavit says only that the blood in the RAV4 is, quote, consistent with an explanation other than, unquote, Avery's being in the RAV4 with an actively bleeding finger, and that James would expect an actively bleeding finger to leave blood in other places. No, not expect. It's not expect. He had a bleeding finger in a RAV4 that left blood other places. Fact. But James' experiments simply assume a number of variables James cannot account for, such as how deep Avery's reopened cut was, how much a partially healed cut would have bled, how he moved about the RAV4, and how and to many other ways blood flakes could end up somewhere. Okay, well, show us. Show us how the blood flakes ended up on there from a cut finger. Wisconsin. James' next experiment purportedly proving that the blood spatter on the rear cargo door was caused by Ms. Halbach being, quote, struck with an object such as a hammer, unquote, with the cargo door open rather than being thrown into the cargo area is irrelevant, even if true. It's nice that they think it's irrelevant on what happened to Teresa Halbach. The point was that Ms. Halbach's blood was in the cargo area, showing that she was at some point bleeding there, not the exact method of how the blood got there. Well, it is very important on how the blood got there. And nothing in Avery's motion or the exhibits he cited supports his conclusion that those bloodstains occurred as, quote, the result of the RAV4 being driven, unquote, anywhere. But again, the question here isn't whether Strang and Buning could have presented James's experiments and opines on what those experiments could show. The question is whether Avery sufficiently pled that it was objectively unreasonable for them not to do so and that he was prejudiced as a result. An explanation why, or even an allegation that it was unreasonable for them not to do so, is absent from Avery's motion. Nor did Avery explain how he could possibly be prejudiced by his attorney's failure to hire an expert that did not rule out anything relevant about the state's case. And Avery has failed to argue on appeal that his motion was sufficient or even that it was objectively unreasonable for Strang and Buting not to hire James. They're not saying he had to hire the exact people. He again merely attacks the evidence submitted at trial. The footnote says, Avery claims in his brief that these experiments were, quote, conducted with 1 to 2 milliliters, unquote, of blood, but James' affidavit never says that either. Whether current post-conviction counsel can attack the trial evidence is not the issue on appeal. Avery makes much of Strang's affidavit, stating that he should have hired a blood spatter, ballistics, or trace evidence expert. But what Strang thinks now is irrelevant. Quote, after an adverse verdict at trial, even the most experienced counsel may find it difficult to resist asking whether a different strategy might have been better, and in the course of that reflection to magnify their own responsibility for an unfavorable outcome, unquote. Quote, Strickland, however, calls for an inquiry into the objective reasonableness of counsel's performance, not counsel's subjective state of mind, unquote. At any rate, Avery did not provide this affidavit to the circuit court until his motion for reconsideration. and therefore it has no bearing on whether the circuit court properly denied the claims raised in Avery's June 2017 motion. Avery's claims that Strang and Buting were ineffective for failing to hire Symes was and is particularly insufficient. They did hire and present a forensic anthropologist who specialized in burned remains, Dr. Scott Fairgrave. So, Avery's claim really is they were ineffective for failing to hire this particular expert, Symes. No, it's not. But an attorney is not deficient for hiring one qualified expert over another. Ineffective assistance, quote, does not consist of the hiring of an expert who, though qualified, God, my back is killing me now, was not qualified enough. The selection of an expert witness is oh my God, that is a big word, paradigmatic. I don't know. That's what I'm going to say that word is. Where's that big word now? Paradigmatic example of the type of strategic choice that when made, quote, after thorough investigation of the law and facts is virtually unchallengeable, unquote. Neither Avery's motion nor his brief says anything about why, from Strang and Buting's perspective before trial, it was unreasonable for them to rely on Fairgrave, who had testified for the prosecution in every case in his career until this one, and who refuted the state's forensic anthropologist, Dr. Leslie Eisenberg's conclusions. Avery gave no evaluation of Fairgrave's trial testimony, nor discussed nor discussed why Symes could accomplish something that Fairgrave's testimony coupled with cross-examining Eisenberg did not. Nor did Avery provide any explanation why it would matter if the char bones found in the Manitowoc County gravel pit were determined definitively to be human, which is all he claims Symes' revelation could have been. If it's not important, why did you give them to the Hallback family? Oh, thank you, Noelle, since I'm looking over here for my virtual back rub. I have degenerative disc disease, and I'm fat, so my back is really sucky, and I have been sitting here at this computer talking to people for 7 hours. So, my back sucks. Though Avery did not even establish that Symes would have said this, Symes' affidavit says only that he believes a microscopic examination could have determined whether the bones in the gravel pit were human, though it gives no explanation why Symes believes he could have accomplished this through microscopic examination when the FBI could not. It's entirely possible Symes would have been unable to do so, or would have determined the bones were not human. So Avery again simply relies on unfounded speculation that Symes would have even established anything relevant. But you gave those bones to the Hallback family. So by you giving those bones, you're claiming they're human. Those bones were found at the gravel pit. You claimed that Stephen did everything at the salvage yard. So if there is anything at the gravel pit, it means Stephen is innocent. So you're giving bones from the gravel pit to the Hallback family. You are saying she was murdered somewhere else. So therefore it cannot be Stephen. Case dismissed. Avery claims that if Symes determined the bones in the Manitowoc pit were human, quote, the state's entire theory against Mr. Avery would have collapsed, unquote. But that is simply false. Both Eisenberg and Fairgrave testified that some of the bones in the Manitowoc County gravel pit could possibly be human. Ms. Halbach's remains were already found in multiple places, meaning they were obviously moved, which both Eisenberg and Fairgrieve testified to. Avery failed to explain why, if the bones in the pit were human and Ms. Halbach's, he or his accomplice, Brendan Dassey, could not have put them there. And Fairgrieve testified that in his professional opinion, Ms. Halbach's remains had been moved to Avery's burn pit, and it was not the primary burn site. Yeah, exactly. Not the primary burn site. State claimed she was burned in Stevens' burn pit. So therefore, if she was burned at the gravel yard, then somebody else did it. Simple. Adding one more location for Ms. Halbach's remains to be found does not shake the state's case against Avery at all. Yeah. Finally, Avery's speculative leap that if any of Ms. Halbach's remains were found in the Manitowoc County gravel pit, then she must have been murdered there is supported neither by Symes' affidavit nor anything else. Symes would have added nothing. Not only did Avery insufficiently plead his claim that Strang and Buting were ineffective for failing to have someone stand, quote, in the vicinity of Mr. Avery's burn barrel, unquote, while it was burning and see if they smelled any plastic, but this claim is also frivolous in the context of this case. The evidence that Avery burned Ms. Halbach's devices in his burn barrel were far from supported only by Fabian's testimony that he smelled burning plastic, as Avery claimed. I'm getting ready to go nuts here. It was also supported by the burned remains of those things found in Avery's burn barrel and by the testimony of Blaine Dassey that he saw Avery toss a plastic bag in his actively burning burn barrel. So, seeing Stephen throw a bag of garbage in a burn barrel that is meant to throw your garbage in means he was burning Teresa Halbach's electronics? Huh. Further, Avery's experiment could not account for environmental conditions on October 31, 2005, any sensitivities of Mr. Fabian's, or the fact that Avery clearly put other items in the barrel as well. More importantly, Avery again did not provide any argument that trial counsel were objectively unreasonable for failing to conduct this experiment, or that there was a reasonable probability of a different result if they had. Avery's argument on this point on appeal consists of a single sentence stating that he, quote, conducted a series of experiments refuting Mr. Fabian's trial testimony that on October 31, 2005, he was in the vicinity of Mr. Avery's burn barrel and smelled, unquote, burning plastic. That does not establish anything about Avery's motion or either prong of Strickland. Avery's claim that Strang and Buting were ineffective for failing to conduct an experiment on a similar bookcase to Avery's bookcase, that Ms. Halbach's Toyota key fell out of the back of when Sergeant Colburn jammed material back into it, is even further afield. First, Avery did not conduct an experiment with, quote, with the bookcase and Toyota key, unquote. Emphasis added. It was their emphasis added. Avery conducted his experiment with a substitute bookcase. Which his video shows was in better condition than Avery's actual bookcase. And an experiment key. Importantly, the experiment key and lanyard were able to be pushed through the back of his experimental bookcase by striking it with a photo album. Further, Avery admitted that, quote, Buting argued that it was impossible for Ms. Halbach's key to have landed in the position it did if it had fallen out of the back of the bookcase, unquote, and that it was, quote, incredibly improbable, unquote, that the key would do so. Buting's arguing this without providing the jury with Avery's new bookcase experiment, definitively proving that the state's theory that the key was pushed out the back of the bookcase was possible and neither deficient nor prejudicial. And now this is in italics. Counsel were not ineffective for failing to pursue Avery's new blood planting theory in accusing Hilgas. This claim, too, was insufficiently pled. Avery did not say who, how, or why someone would have the knowledge and tools necessary to collect or transport his blood from his sink to create the blood stains found in Teresa Halbach's RAV4, or how they could have accomplished this while leaving no trace of themselves. And the footnote says, these trial exhibits and other items not electronically maintained are in the appellate record. However, these non-electronic items were not given record numbers by the clerk of circuit court. The state therefore references them by exhibit number, but notes that they are found in the non-electronic materials. Avery's blood spatter expert, James, used pipettes and an applicator to create similar blood stains in a test RAV4, which Avery claims proves that the killer planted Avery's blood in this manner. Why anyone would just happen to have pipettes and an applicator on hand while trying to plant the RAV4 defies explanation. And Avery offered none. It is also utterly unsupported by any fact of record, nor did Avery explain how someone would have kept his blood liquid long enough to plant it in droplets, or why someone would come back half an hour later, this time apparently with a scalpel, to collect dried blood flakes from his sink. And Avery did not explain how a person would have successfully transported those to the victim's RAV4 either. Moreover, the only way onto the portion of the property with Avery's trailer on it required a person to drive west, past Barb Yanda's trailer and all of the business buildings to get there, because there was a 20-foot berm separating Avery's trailer from access to the rest of the salvage yard and the Redon pit. Avery claims he and his brother Chuck saw taillights near Avery's trailer while the two were, quote, leaving the Avery property, unquote, and they turned around to investigate, at which time someone purportedly drove the RAV4 back to Cuss Road. But to get anywhere near Cuss Road, the person would have had to drive directly toward Avery and Chuck before turning south into the salvage yard. Avery fails to explain how a person could have driven the RAV4 to and from his trailer undetected twice in this scenario. Nobody says he was driving the RAV4. Nobody said that it was the RAV4 that was driving, that went to Stevens. Never said. Now I am on page 52 of 130. My God, and it is 9:30 p.m. my time. So sorry for those of you that it's way later. I have no idea how long this is going to take. Avery particularly failed to explain how Ryan Hilgas, Ms. Halbach's former boyfriend and longtime friend, could have accomplished any of these things. Avery did not explain, 1, how or why Hilgas would have had any familiarity with the Avery property or surrounding area. 2, where, how, or when Hilgas could have killed Ms. Halbach or burned her remains. 3, how or where Hilgas sat for days undetected in the RAV4 waiting to see Avery leave the property. 4. When Hilgas could have planted the blood evidence in the RAV4 or the RAV4 itself when multiple people were with Hilgas all night on November 3 and all day and late into the night on November 4, his accomplices. Who this alleged accomplice was, who Avery claimed helped Hilgas leave the property, or that one even existed. Well, it would be the people that it was Scott Blodorn, Ryan Hilgas, and Halbach were signing in and out to the Avery property. And yes, this live will be left up. 6. How or when Hilgas could have transported and disposed of the victim's remains and effects with no one noticing. 7. How he would have gotten Ms. Halbach's DNA onto Bullet, the magic bullet, and placed it in Avery's garage. 8. How anyone could have driven Ms. Halbach's RAV4 onto the property near Avery's trailer. Nobody's saying that happened. Or 9. Where Hilgas supposedly hid Ms. Halbach's RAV4 between October 31 and November 4 that precluded it from being found. Additionally, and perhaps more importantly, Avery provided not one shred of evidence from the record to establish that any of the facts he alleged about this theory existed, other than his own self-serving affidavit and rank speculation. Nearly all his alleged facts are unsupported by any record citations, and the few things Avery does cite do not establish what he concludes. For example, Avery provides nothing showing that Ms. Halbach's RAV4 collided with a post on Cuss Road. He simply provided a picture of the post and concludes that because the RAV4's directional light was knocked out, quote, the killer, ... collided with the post while attempting to plant the RAV4, unquote. The existence of the post is not a fact that supports Avery's conclusion that Ms. Halbach's RAV4 collided with it, let alone that the killer did so while trying to plant the RAV4 on Avery's property. And this is where my blood starts boiling again, because you're claiming everything that Kathleen has said is speculation. Well, everything you prosecuted Stephen on is fucking speculation and made up evidence and planted evidence. That assertion remains mere speculation and insufficient to support granting a hearing. And every fact Avery alleged about this tale suffers the same failing. Counsel are not ineffective for failing to investigate facts that don't exist, and allegations with no factual support are insufficient to entitle Avery to a hearing. Nor would Avery's non-existent facts be enough to prevail on a Denny motion, alleging Ryan Hilgas was a possible third-party suspect. Nothing he alleged in his motion established jealousy as a motive. It was, like the rest of Avery's allegations, unsupported by the record and spun entirely from conjecture. Avery provided nothing establishing, one, that the abusive relationship Halbach supposedly was in with Hilgas, look in her diary, you have it. 2, that Hilgas knew about Halbach's sexual history with Blodorn, and 3, even if Hilgas did know about it, that he cared. Avery just proclaimed, with no evidence whatsoever, that Hilgas committed perjury about it. Nor did Avery point to anything suggesting or attempt to explain why, after 4 years of uneventful platonic friendship where Hilgas saw Halbach at least once a week, Hilgas suddenly became jealous about Halbach seeing other men. And not just jealous, but out of the blue, Hilgas became so enraged as to commit murder. Further, Avery did not provide anything directly connecting Hilgas to the crime. Well, why would Stephen commit this crime? Why is it more believable that Stephen, who has nothing against this woman, would kill her? Avery could not have prevailed on a Denny motion alleging Hilgas was the killer because all of his alleged facts are pure speculation. No, pure speculation was Kratz's whole case against Stephen, and then how they were completely different against Brendan. Counsel is not ineffective for failing to bring claims that would have been denied. Fuck you. Avery's appellate brief on this claim is even further off point. Not only does he make no argument that he sufficiently pled his motion, he now claims trial counsel were ineffective for failing to establish Hilgas as a Denny suspect by impeaching his testimony at trial in various ways. That does not make sense. A Denny motion would have to be filed before trial, and obviously trial counsel cannot rely on trial testimony as support for a pretrial motion. And Avery has, once again, attempted to obscure his piecemeal litigation by including several arguments about what counsel should have done to, quote, establish Mr. Hilgas as a Denny third-party suspect, unquote, that either weren't raised until his motion for reconsideration or were not raised in the circuit court at all. 7. These are inappropriate considerations for determining whether the circuit court properly denied this claim, which was raised in Avery's June 2017 motion. Avery's claims on this point on appeal are insufficiently briefed, and to the extent they state any claim, they are impermissibly based purely on hindsight evaluation of Hilgas's testimony that is insufficient to show ineffective assistance. And considering the actual facts of record from counsel's perspective at the time of trial, as Strickland requires, the record conclusively demonstrates that it was not only reasonable trial strategy, but the best possible trial strategy to allege that the blood in Halbach's vehicle came from the blood vial. This is so funny that they're now trying to say that Strang and Buting did the best job from the blood vial and was planted by law enforcement. Avery had a pending lawsuit against Manitowoc County law enforcement officers. Law enforcement obviously had far more control over the scene and the evidence than anyone else. Trial counsel knew that they could show that law enforcement potentially had access to a vial of Avery's blood. And before trial, there was no existing protocol for testing EDTA, anticoagulation preservative in blood, which is what the purple stopper. Are we really going to go into this when this was already said that we know it's not that blood? I mean, so talk about a waste of trees. Once the state learned of the vial, it sought to adjourn the trial so it could attempt to find a lab to create and validate a testing protocol and to test the vial of blood and Avery's blood found in the RAV4 for EDTA, but the trial court refused. Trial counsel could not know before trial that the state would successfully procure the FBI to create and validate a protocol to test for EDTA, complete the testing before the end of the trial, and that the circuit court would admit the expert's testimony about the results showing that the blood from the vial had EDTA in it, but the blood in the RAV4 did not. And even then, defense counsel had the reasonable option of attacking the newly created protocol on the theory that the FBI's test was hurried and unreliable, and that the detection threshold used was too high to show EDTA in the blood from the RAV4, which is exactly what defense counsel did, including by calling their own expert chemist to say so. And though current post-conviction counsel now faults them for that decision, that fault is based entirely on hindsight. Reasonable tactical choices, quote, that make particular investigations unnecessary, unquote, are, quote, virtually unchallengeable, unquote. And trial counsel's strategic decision not to seek to test the blood sample so that there was no definitive finding on the presence or absence of EDTA in the vial of blood or the RAV4, and hope the state would not be able to do tests in time, was a reasonable tactical decision before trial. Avery has simply declared that in hindsight, this strategy was foolish because it failed. This does not show ineffective assistance. Furthermore, defense counsel did not, quote, commit themselves to one theory about the source of the planted blood, unquote. At trial, they specifically established thorough cross-examination of the FBI expert that the blood could, quote, have been planted from some other blood source that didn't have EDTA already, unquote. The jury heard the theory that the blood could have been planted from some other source than the vial. It just rejected it. Avery cannot show that counsel were ineffective for failing to make an argument that they did in fact make. None of Avery's allegations sufficiently meet either prong of Strickland. In sum, in both Avery's motion and his brief, he relied on the erroneous conclusion that if he were able to come up with any theoretical explanation for the evidence that aligned with this alternative planting theory, no matter how speculative, or achieved any outcome that aligned with it by conducting a loosely analogous experiment, then he had proved that what the state alleged was impossible, proved that his alternate scenario is what happened, and therefore proved that Strang and Buting were ineffective for failing to do these things. But as shown, Avery proved nothing. His experts did not come to any conclusions that were inconsistent with the trial evidence, and Avery's experiments showed only that these experts, and sometimes merely post-conviction counsel and her law clerks, could make a certain result occur if they tried. It is basic logical fallacy to conclude, one, that if A could lead to B, it must lead to B, and two, if this particular A leads to B, no A could lead to anything but B. Given the conditions under which most of Avery's experiments were conducted, and that they were biased toward trying to achieve a particular result. Wrong. Avery's reasoning was even more flawed than that. What Avery really concluded was that he was able to make some particular A lead to B, therefore no X could ever lead to Y. Nevertheless, faulty logic in hand, both here and in the trial court, Avery noted that there were cases where counsel was found deficient for failing to consult an expert, but failed to show they were in any way comparable to this case. He concluded that his spurious experiments would have been admissible without any developed argument applying the law to show that was true. And based on these unsupported premises, declared that he had shown that Strang and Buting were ineffective. But Avery uniformly failed to address the two prongs of ineffective assistance. Sorry. Another message. He failed to show that it was objectively unreasonable from Strang and Buting's perspective at the time of trial to opt to suggest to the jury that law enforcement had a vendetta against Avery and planted the evidence against him using the blood vial and other sources. He failed to show it was unreasonable to cross-examine the state's 14 experts instead of using their entire budget, which there's a footnote on that, and the footnote says, stating that Strang and Buting, quote, were retained by Mr. Avery for $220,000, unquote. Stating that current post-conviction counsel has spent $232,541.98 in retaining these experts. Okay, back to consult these additional experts with no idea what they might say. And he failed to show that Strickland required them to attempt to construct a narrative, no matter how flimsy, that a particular person somehow collected Avery's blood from his sink and planted it in the RAV4 to account for the EDTA evidence. evidence that, again, trial counsel did not think would be available and made a strategic decision not to pursue. Perhaps most importantly, Avery failed to show there is any reasonable probability that the jury would have acquitted him if, instead of Strang and Buting's easily understood defense of suggesting that law enforcement framed Avery and planted the evidence, the jury was presented with a, quote, battle of the experts, unquote, in an attempt to support the frankly fantastical theory that Hilgas inexplicably flew into an unprecedented fit of rage, secretly abducted the victim, shot her, and burned her remains in some unidentified location, somehow knew his way around the Avery property, and decided to frame Avery. Well, that sounds a lot like what Kratz talked about, what he claimed Brendan did. But then Brendan isn't in Stevens' trial. But he said in Stevens' trial, there's only one person responsible, but then prosecuted Brendan. Then on November 3, according to Avery's new theory, despite having spent all afternoon and late into the night with multiple people who could confirm his whereabouts, Hilgas was also somehow at the Avery property around 7:30 p.m., like during the Penny Bernstein case when Stephen had receipts from where he was, yet he went to prison for 18 years. Knew Avery left the property, knew how to access the property, drove the RAV4 onto the property, broke into Avery's trailer unnoticed, ran to Avery's sink in the half an hour after Avery bled, conveniently had pipettes and an applicator on hand, successfully collected enough liquid blood to plant, and planted the blood evidence in the RAV4 before the blood coagulated. Hilgas then inexplicably waited half an hour until the blood dried and went back in, this time with the scalpel, and scraped some flakes off of Avery's sink, somehow transported those to the RAV4 unharmed, planted those as well, and then drove away and hid the RAV4 somewhere. And then the footnote says, Avery's later claims that Strang and Buting were ineffective for failing to claim that Bobby Dassey, rather than Hilgas, was the real killer, fail for many of the same reasons. And then a day later, as Avery's new theory continues, between organizing search parties all day and with multiple other people, his co-conspirators, Hilgas somehow, again unnoticed and at some unidentified time, snuck back onto the property and covered the RAV4 with debris. He further managed to creep around Avery's property at some other unspecified time, and again unnoticed, to plant the victim's burned personal effects in Avery's burn barrel and her remains in at least 2 places. He also managed to arrange for an escape with some unidentified accomplice, again unnoticed. All this, yet Hilgas left no trace of himself. He left no trace of himself. Well, that happens, right? No trace of Teresa Halbach in Stephen's trailer or garage. Imagine how that happens. Nor anything else supporting this theory anywhere, nor did his spectral accomplice. And Avery said nothing about how Hilgas could have placed Halbach's DNA on the magic bullet, which was shot from the gun. Nope. This is speculation. You're stating as fact, and this is not fact, when you say was shot from the gun in Avery's possession and found in Avery's garage. Speculation, no fact. You've never proven that. Avery made no showing, nor really even any argument, that there is any probability any rational jury would have rejected Strang and Buting's reasonable defense. I just think this is hysterical that the state is trying to make it out like Strang and Buting are the greatest ever. And believe this, likely because there isn't any. Accordingly, Avery did not allege sufficient material facts that, even if true, would show that Strang and Buting were ineffective. And by failing to meet this pleading burden regarding trial counsel's performance, Avery necessarily failed to meet it as to Hagopian and Askins as well. Moreover, the record conclusively refutes Avery's ineffective assistance of trial counsel claims. Quote, fair trial is one in which evidence subject to adversarial testing is presented to an impartial tribunal for resolution of issues defined in advance of the proceeding, unquote. Avery provided nothing showing that Strang and Buting did not show active and capable advocacy or did not subject the state's case to meaningful adversarial testing. All of the state's witnesses and evidence were thoroughly contested at trial by the defense. And trial counsel gave compelling closing arguments suggesting that several people, and specifically Bobby Dassey, also known as the killer, could have committed the crime, and that the state's evidence was too unreliable and likely planted by law enforcement. That was the best defense available because it was the most believable defense that accounted for the physical evidence, and trial counsel ably presented it. They thoroughly, sometimes even doggedly, cross-examined the state's witnesses, presented their own forensic anthropologists to opine that the victim's remains were brought to Avery's burn pit, and presented their own chemists to point out flaws in the FBI's EDTA protocol and conclusions about the EDTA test. Avery did not set forth a single fact showing that Strang and Buting's performance was objectively unreasonable in any respect or could have done differently. This is manifestly insufficient to warrant a hearing on an ineffective assistance of counsel claim. Because Avery received effective assistance from his trial attorneys, his post-conviction attorneys were not ineffective for failing to raise the claims Avery now advances. Quote, failure to raise a losing argument, whether at trial or on appeal, does not constitute ineffective assistance of counsel, unquote. C. Avery failed to sufficiently plead that Hagopian and Askins were ineffective for failing to raise his new ineffective assistance of trial counsel claims. Even assuming Avery had properly alleged sufficient facts supported by the record and developed an argument that would show ineffective assistance of trial counsel, though he still did not do so for Hagopian and Askins. His comment still would have been properly denied for failing to overcome the procedural bar under section blah blah. Avery just proclaimed that if Hagopian and Askins hired these experts, they would have been able to present Avery's new defense, and they, quote, should have interviewed Mr. Avery to learn, unquote, the allegations he made to support this new defense. That provides no fact showing why or how Hagopian's and Askins' decision to present the claims they raised was objectively unreasonable. Nor does Askins explain why he never bothered to give Hagopian or Askins this purported information about these events, if any of it were true. Quote, what investigation decisions are reasonable depends critically on information supplied by the defendant, unquote. Those were the key requirements for Avery to sufficiently allege deficient performance. Additionally, nowhere in Avery's motion or his brief did he give any real evaluation of the comparative strength of the claims from the objective perspective of an attorney looking at the record immediately after trial. He just repeatedly described his new claims as clearly stronger and his previous claims as clearly weaker. But he again provided no actual analysis to support those statements. For example, He reinstated the legitimate tendency test from Denny and then stated that, quote, there was no realistic possibility that the post-conviction attorneys would be successful in reversing the trial court's decision, barring the third-party evidence at trial, but that, quote, is the defendant's opinion only, and it does not allege a factual basis for the opinion, unquote. Avery, quote, must say why the claims, ... were clearly stronger than the claims actually raised. His motion is devoid of any such explanation, unquote, and is thus conclusory. What Avery did allege amounts to more Monday morning quarterbacking, with the benefit of hindsight. Avery just listed the reasons the court rejected the third-party perpetrator evidence claim and reiterated that if Haggapian and Askins had hired these experts, they could have presented his new defense. That does not support Avery's allegation that this claim was clearly weaker than the claims he now raised, because it says nothing about the apparent strength of the claim, quote, from counsel's perspective at the time, unquote. A defendant doesn't show that one claim is weaker than another simply by showing the claim failed. Haggapian and Askins could not have known how the trial court would rule on the claim at the time they filed their motion. And fatally, Avery never even mentioned the Fourth Amendment, juror dismissal, or ineffective assistance claims pursued by Haggapian and Askins, apart then to note they were raised on direct appeal. The juror dismissal and ineffective assistant claims were particularly strong. Were they? They were particularly strong? Okay. The circuit court engaged in ex parte communication with a juror that it later excused, arguably in violation of controlling case law. Moreover, Wisconsin statute blah blah required a court to discharge alternate jurors before deliberations, which the trial court failed to do. Avery had a particularly compelling argument that the trial court misapplied State versus Lehman, which stated that, quote, in the absence of consent by the defendant to such substitution, ... when there's a ... it means they're cutting out words and just cherry picking what they want in there. It is reversible error for a circuit court to substitute an alternate juror ... after jury deliberations have begun, unquote. And then, they emphasized then, and then Haggapian and Askins argued that Strang and Buting were ineffective for, quote, agreeing that ... the juror would be excused, unquote, if a sheriff's deputy verified the facts the juror told the judge and, quote, entering into a stipulation allowing the court to substitute an alternate juror, ... a procedure not permitted by statute, unquote. Haggapian and Askins found concrete legal issues. Does anybody else find this very tiring? That we have to keep going over stuff that Stephen's prior attorneys did, and you're not talking about what his current attorney has found and why they aren't talking about that. And so this is a lot of, we're going to fill in all this bullshit here. Make it look good. Sorry. And two instances where his attorneys had agreed to things that, had they disagreed to, would have resulted in a mistrial, one of which was contrary to statute. They had a much more compelling argument that those actions were objectively unreasonable and that they prejudiced Avery than his new ineffective assistance of trial counsel claims, which are supported by no facts of record and which say nothing about the reasonableness of Strang and Buting's decision making. The fact that Hagopian's and Askin's claims did not prevail does not mean that they were not the strongest claims they could have brought. And Avery failed to discuss the strongest claims at all in his post-conviction motion. Accordingly, he failed to plead sufficient facts to show that Hagopian and Askins performed deficiently. And on top of failing to allege any material facts that would show deficient performance, Avery's motion said nothing about prejudice. The closest it came was Avery's repeated assertion that if Hagopian and Askins had hired these experts, they could have alleged that Strang and Buting were ineffective in this manner. A defendant who presumes prejudice fails to sufficiently plead his motion. Again, to be entitled to a hearing, Avery had to meet the Allen requirements in his motion to the circuit court. He cannot cure the deficiencies in his motion in his appellate brief. Still, Avery's brief on this point is no better pled or argued than his motion. Avery again relies entirely on conclusory allegations. For example, he claims trial counsel, quote, presented no real defense, unquote, because, quote, called 7 witnesses and only 2 experts, unquote. But nowhere does he explain why objectively reasonable trial strategy required more witnesses, why calling 2 experts was insufficient, or what was insufficient about Strang and Buting's cross-examination of the state's experts. Avery never discusses any of the testimony at trial to show what was lacking in trial counsel's performance. And now I am on page 65 of 130. So we have been live for almost 2.5 hours and we're like halfway done. And I have been on since 2 p.m. and it is 10 p.m. Ugh. In short, quote, in attempting to construct a better defense for a retrial, Avery did not do enough to show that a new trial was required, unquote. Avery's claims raised in his June 2017 motion were insufficiently pled, meritless, even if the facts he alleged were true, and his motion is procedurally barred because he lacks a sufficient reason for failing to raise his claims previously. The circuit court properly denied his motion without a hearing. B. The circuit court properly exercised its discretion in denying without a hearing Avery's claims related to the 2016 and 2017 scientific testing. That just bothers me. The whole properly denied without a hearing. So properly without hearing any evidence, it is okay to just lock a person in prison. Avery's scientific testing related ineffective assistance of trial counsel in newly discovered evidence claims. Avery raised 2 ineffective assistance of trial counsel claims in his June 2017 motion. We're still in 2017. Kathleen filed in October of 2019. But let's just keep talking about 2017. That the circuit court addressed on the merits. 1, that trial counsel were ineffective for failing to have trace evidence expert Dr. Christopher Palahniuk establish that the key to Ms. Halbach's RAV4 found in Avery's trailer was not the primary key. That's a fact. And 2, trial counsel were ineffective for failing to have DNA expert Dr. Carl Reich. Didn't have to have that expert. They just should have had an expert perform experiments about the quantity of DNA left on a test Toyota key and a test hood latch through touch. Yeah, look at that. Doing real experiments. Avery also alleged that the additional scientific testing he performed yielded newly discovered evidence warranting a new trial. This testing was performed on the following: damaged bullet fragment the magic bullet, which was collected from Avery's garage and was found to have Teresa Halbach's DNA on it, which was DNA from her chapstick that for some reason they took from her home and brought it to Stephen's house. Why are you bringing stuff, including her vibrators, to Stephen's? Unless you're gonna use that DNA. Source testing the swab from the RAV4 hood latch, which had yielded Avery's DNA, and source testing and quantity testing the swab from the key to the RAV4 found in Avery's residence, which had also yielded Avery's DNA. Regarding bullet fragment, the magic bullet, Avery procured Dr. Lucian Haig, a ballistics expert, to shoot similar .22 caliber long rifle bullets through some bone samples. Palahniuk then examined both the test bullets and the magic bullet using advanced microscopy techniques. Particles, quote, consistent with the appearance of bone, unquote, appeared on the test bullets. He alleged that, quote, no particles consistent with bone, unquote, appeared on the magic bullet. Palahniuk noted, though, that the observations he conducted were, quote, not necessarily inclusive of all particle types that may be present, unquote. And he could not definitively say what any of the particles were without further testing. Haig opined that bone fragments would have been detected on the magic bullet by the state's forensic expert, William Newhouse, who microscopically examined it before trial. Yeah, that all makes sense. Avery alleged that, quote, because no bone fragment was identified on the damaged magic bullet over the course of its examination, unquote, at the Wisconsin State Crime Lab, and Palahniuk did not see anything he believed was bone particulate on the magic bullet, the damaged bullet, quote, was never fired through Ms. Halbach's skull, unquote. Yeah, fact. Avery alleged this, quote, completely disproved, unquote, that she was fatally shot in the head. Yeah, it does. Next, Avery alleged that Palahniuk, quote, used a microscope developed in 2016 to analyze the hood latch swab, unquote. Avery provided no other information about this examination. Because let's have an evidentiary hearing and then you can hear more. Dr. Reich conducted source attribution testing to see if it could be determined what body secretion had yielded Avery's DNA on the hood latch. He noted that there are only 4 forensic body fluids for which reliable forensic tests exist: blood, semen, saliva, and urine. He acknowledged that humans, quote, make a variety of other body fluids, unquote, but, quote, there are no tests for these. And thus these fluids are, there are no tests for these, ... And thus these other fluids are invisible to forensic analysis, unquote. Reich ruled out all 4 detectable fluids. He concluded that the DNA's source could not be determined. Reich also conducted an experiment in which individuals opened the hood of a RAV4. They have to use a test RAV4 because you won't turn over the actual one, even though it is in writing. It is agreed upon to turn it over to Stephen's lawyer. The hood latch was then swabbed and tested for DNA. The experiment was conducted 15 times. In 11 of them, the volunteers did not deposit a detectable amount of DNA, but in 4 of them they did. Avery claimed this demonstrated that his, quote, DNA was never deposited on the RAV4 hood latch, unquote, and therefore Strang and Buting were ineffective for failing to hire Reich, just said should hire an expert, to perform this experiment. During execution of the search warrant for Avery's DNA, a swab of Avery's groin had been collected by a nurse, but was thrown away, allegedly, when investigator Wiegert and agent Fassbender conferred and determined groin swabs were not authorized by the warrant. Reich speculated that the discarded swab from Avery's groin could have yielded a large quantity of DNA. Avery concluded that this proved that the discarded groin swab was substituted for the hood latch swab, notwithstanding Fassbender's report stating that the groin swab was discarded. Well, prove it, Fassbender. Why are we just to take Fassbender's word for it that he threw it away, even though Stephen was there and didn't see it thrown away, and it wasn't reported in the nurse's report? Finally, Avery claimed that Palahniuk had determined that the RAV4 key collected from Avery's residence was likely of subkey, not likely, it was, due to its shape and the amount of debris on it, well, lack thereof, which Avery claimed proved it was planted. Reich applied source DNA testing to the swab of the key and determined that Avery's DNA on the item likely came from skin cells, because he again ruled out the 4 bodily fluids for which there were tests. He then conducted an experiment having Avery hold a similar key in his hand for 12 minutes. The experimental key, quote, yielded 10 times less DNA, unquote, than what the crime lab had extracted from the RAV4 key, which Avery contended proved that his DNA on the RAV4 key was planted by someone having stolen his toothbrush. Yeah. There you go. All right there. Thank you for putting that in there. The circuit court's decision. The circuit court noted that Avery's argument about the results of this testing, quote, left out several significant facts, unquote. First, Reich had conceded, quote, that there is no forensic test available that can conclusively determine whether DNA was left by sweat. As such, the report cannot conclusively state that the DNA on the hood latch could not have been left by the sweat of the defendant's hand, unquote. No such thing as sweat DNA. Quote, furthermore, while 11 of the test subjects did not leave detectable DNA on the hood latch, the fact remains that 4 of the test subjects did leave detectable DNA by touch, unquote. The circuit court concluded that, quote, contrary to the defendant's assertions, the test of the DNA on the hood latch does not rule out the defendant's hand of the source of the source of the DNA, unquote. And, quote, in fact, the report declines to make such a conclusion, ... unquote. But it is also reasonable doubt. Regarding Avery's arguments about the RAV4 key, the court noted that, quote, there is no question that the DNA found on the key was Avery's. Unquote. It noted that, quote, secondary keys are frequently used when an individual misplaces the primary key, unquote. And Avery had provided nothing showing that the victim was not using a subkey on the day of her murder. It found Avery's assertion that, quote, someone took his toothbrush and planted the DNA on the subkey supported, unquote, supported by only Avery's own conclusory allegations. So Teresa Halbach's sister gave her the lanyard, the blue lanyard. But there's only part of it there. Where's the other part of it that Teresa's sister testified about? Why did Tom Pierce and her friend testify that Teresa was petrified of losing keys? That there were jokes made about it, about her losing keys. So if you're somebody who is scared of losing keys, why would you have only one key on your key ring? So you're going to have a separate key ring that has your house key, your business key, and your car key, but then you're using your valet key? Where's your real key? Makes no sense. Finally, the court noted, not finally in this, we're only on page 68 of 130. Finally, the court noted that Palahniuk's report about his observations of bullet fragment, magic bullet, was not as clear-cut as Avery claimed. Palahniuk's report indicated that the tests were not completely inclusive of everything that may be present on the bullet, and to do that, a, quote, more detailed analysis would be necessary, unquote. The report, therefore, did, quote, not support Avery's position, unquote. The circuit court further noted that all these items were admitted at trial and, quote, each was thoroughly contested by defense counsel, unquote. Quote, the reports submitted by Avery are equivocal in their conclusions and do not establish an alternate interpretation of the evidence, unquote. It found that, quote, given the totality of evidence submitted at trial and the ambiguous conclusions as stated in the experts' reports, it cannot be said that a reasonable probability exists that a different result would be reached at a new trial based on these reports, unquote. 1. Legal standard and standard of review for newly discovered evidence claims. Where a defendant seeks a new trial based on newly discovered evidence, he must show, quote, by clear and convincing evidence that 1. The evidence was discovered after conviction. Yep. 2. The defendant was not negligent in seeking to discover it. Yep. 3. The evidence is material to an issue in the case. Yep. And 4. The evidence is not merely cumulative. Yep. All there. Check, 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 check. If the defendant satisfies all 4 criteria, quote, then the circuit court must determine whether a reasonable probability exists that a different result would be reached in a trial. Hold on, please, for a second. Hold, please. Something popped up that I need to do real quick. Sorry, my other screen is going really slow at the moment. If the defendant satisfies... Sorry, you're going to hear me talking right here. It's freezing. Okay. Now let's see. Sorry. I'll get back into this. All right. Where was I? All right. Quote, a reasonable probability of a different result exists if there is a reasonable probability that a jury, looking at both the old and the new evidence, would have a reasonable doubt as to the defendant's guilt, unquote. Quote, newly discovered evidence, however, does not include the new appreciation of the importance of evidence previously known but not used, unquote. Evidence previously known includes evidence that was knowable by counsel. Additionally, a new expert opinion based on facts available at the time of trial is not newly discovered evidence as a matter of law. It is a new appreciation of the importance Ungrounded on Friday, yeah. Um, but not used. Quote, if the newly discovered evidence fails to satisfy any one of these 5 requirements, it is not sufficient to warrant a new trial, unquote. Quote, the decision to grant or deny a motion for a new trial based on newly discovered evidence is committed to the circuit court's discretion, unquote. And the court reviews that decision, quote, for an erroneous exercise of discretion, unquote. 2. The circuit court properly rejected Avery's claims related to the DNA testing. The circuit court properly exercised its discretion in denying Avery's newly discovered evidence and ineffective assistance claims related to this testing. Avery failed to meet the first 4 prongs of the newly discovered evidence test. Avery provided no facts or argument showing that any of this evidence met the first 4 prongs of the newly discovered evidence test, and again relied on conclusory allegations. Avery said only that, quote, through the use of new technology previously unavailable, Mr. Avery has discovered new evidence that shows his conviction was the result of a manifest injustice. Much of the evidence was discovered diligently after the new technology became available. Further, the evidence is crucial to the issue of Mr. Avery's guilt or innocence and is not cumulative, unquote. He further alleged that he, quote, satisfies the first 4 prongs of the test, unquote, because unexplained, quote, technological advancements, unquote, occurred after Avery's trial. Quote, therefore, Mr. Avery was not negligent in failing to have any of these tests conducted, unquote, and, quote, clearly, unquote, they're material and non-cumulative. None of that relates any facts about Avery's alleged new evidence to prongs of the test to show that it actually meets them. It is simply a recitation of the test. Avery does not explain to what technology he is referring when this technology became available, what this technology can show that previous technology could not, or why his various experiments could not have been conducted at the time of trial or during any of the other post-conviction litigation. So why don't you just have an evidentiary hearing and you'll hear all those answers? In fact, Avery's conclusory statement admits that some of Avery's evidence cannot meet the first 4 prongs of the test, considering that only much of it, and what much includes is unclear, was discovered diligently and with technology previously unavailable. Technology. I'm going to get slap happy now. Further, Avery's own motion refutes that this evidence was unknowable at the time of trial. Haig claimed that Newhouse's microscopic examination would have revealed bone particles on bullet fragment FL, the magic bullet, during Newhouse's examination at the time of trial. Avery has now attempted to recast this as an ineffective assistance claim, but that is not the argument he made in the circuit court, so it is forfeited. Similarly, Dr. Kenneth Olson, the state's trace evidence expert, used the same exact technology and performed the same type of elemental analysis on the charred bone fragments before trial that Palahniuk performed on bullet fragment, the magic bullet, in 2017. Palahniuk just used a newer microscope. Well, it would be important to use newer. But the date the microscope was manufactured doesn't show that the technology used advanced in any material way since Olson's examination in 2005. Avery could have conducted this type of examination on the magic bullet then. The technology obviously existed in 2005 to determine how much DNA was deposited on an item, seeing as the Wisconsin Crime Lab did so with the evidentiary swabs. That means Avery's key experiment, holding a key in his hand, provides nothing that was unknowable at the time of trial. either because all of Avery's new conclusions were based on comparing the amount of DNA left on the key during his experiment to the amount of DNA the crime lab detected on the key swabs. Well, come on, jury. Anybody other than the jurors that work for Manitowoc County Sheriff's Department, if you knew about that experiment, would it change your thoughts any? The record conclusively demonstrates that Avery merely provided new expert opinions based on facts available at the time of trial. This is not newly discovered evidence as a matter of law. Yeah, whatever. The footnote says, Olson explaining that he used a, quote, scanning electron microscope with an energy dispersive X-ray analyzer, unquote, to identify different elements present on the bone fragments to determine whether elements characteristic of bone could be detected on Magic Bullet. Avery dichotomously, I can't pronounce that word, claimed in his motion that the quantity testing results were both newly discovered evidence and that Strang and Buting were ineffective for failing to present them. Though, by definition, an attorney cannot be ineffective for failing to present newly discovered evidence, the state will address both contentions because Avery can meet neither. We are now on page 72 of 130, and we are at 10:30 p.m. Really, the only reason I'm still going is because my partner is still at work. So whenever he comes home, depending on how much it is left, I may end this video and finish the rest tomorrow. Yes, Cindy, I've been on all day. I went live at 2 p.m. my time, and it's now 10:30. And I haven't had dinner. I'm starving. In short, Avery's motion failed to show by clear and convincing evidence that he meets the first 4 prongs of the test for a newly discovered evidence claim. Avery failed to show a reasonable probability of a different result. Even so, as the circuit court aptly concluded, Avery failed to meet the 5th prong as well. And because that prong required the circuit court to assess whether there was a reasonable probability of a different result if the DNA quantity experiments on the hood latch and key, and establishing that the key may be a subkey, were admitted at trial, it properly denied Avery's claims that Strang and Buting were ineffective for failing to have these experiments performed because Avery failed to show that it was prejudicial. It further properly denied Avery's groin swab and toothbrush stories as insufficiently pled. Avery's experiments on the hood latch would actually support the state's case more than Avery's. As the circuit court noted, Reich admitted that there is no forensic test that can detect sweat. Reich later also admitted that while sweat technically has no DNA itself, it can have slough skin cells in it that do carry DNA. And Reich's source attribution testing found that, quote, all 4 body fluid tests provided negative results, ... unquote. For the hood latch swab, meaning Avery's expert ruled out any of those substances, showing that DNA could indeed have been left by Avery's touching the latch and depositing sweat with the skin cells in it. The touch experiment on the hood latch supports the state's case as well. Nope. In Avery's experiment, individuals left their DNA on the hood latch 4 out of 15 times, which is 26%, or better than 1 in 4, showing that it is possible to do so even when someone opens the hood under controlled, non-stressful, low exertion conditions. Given that Reich's experiment cannot account for the environmental factors and the many other variables that could have led to Avery's depositing more skin cells on the hood latch than the individuals in his experiment, Reich's experiment does not undermine the state's case against Avery at all. Avery admits any mention of this result in his brief. Avery's elaborately woven scene where investigator Wiegert and Agent Fassbender intentionally directed the nurse to take the groin swab confiscated it and surreptitiously substituted it for the hood latch swab has no factual support in the record and therefore cannot support either Avery's ineffective assistance or nearly discovered evidence claims. Well, you can't prove that they threw it away. Avery based the scenario entirely on the failure of the nurse to note on her report that a groin swab had been taken but discarded, which, according to him, quote, a well-qualified nurse, unquote, would have done, and the fact that Wiegert and Fassbender instructed Deputy Hawkins and Sergeant Tyson to swab the hood latch, battery cables, and interior and exterior door handles, but did not include the interior hood release lever and hood prop. Avery claimed this showed the investigators were not making, quote, a good faith effort, unquote, to collect evidence. Avery then apparently concluded that this supplied the factual support for any nefarious scenario about the DNA evidence he could envision. Avery's opinion that Wiegert and Fassbender should have instructed the investigators to swab more areas is not a fact, and it supports nothing. Well, it shows they suck. It certainly lends no support to his claim that Wiegert and Fassbender intentionally and in bad faith confiscated and substituted the groin swab for the hood latch swab. Well, you're not proving that they didn't. Avery's unfounded speculation about what, quote, a well-qualified nurse, unquote, would log on the form is also his opinion. No, it's not opinion. Supported by nothing and is not evidence. The perspicuous and factually supported reason the groin swab is not listed on the nurse's report is because it was discarded. No. That's not the way this stuff works. You have to have that in the record. As Fassbender's report shows, and therefore not, quote, obtained for DNA and released to Sergeant Bill Tyson, unquote. Something discarded would not be entered on a report intended to document what the hospital is transmitting to law enforcement for the obvious reason that it is not being transmitted to law enforcement. Anything else is pure speculation. Avery has also materially misrepresented Reich's affidavit. At no point does Reich, quote, offer the opinion that a rubbed groin swab taken from the defendant was relabeled and thus became evidence from a hood latch, unquote. Reich said, quote, it is hypothesized that a rubbed groin swab, unquote, could have been relabeled. Reich specifically opined that, quote, the convenience of this explanation, does not prove evidence tampering or more precisely evidence reassignment, unquote. In short, all parts of this tale are unsupported by any facts. That sounds like Kratz's story. Unsupported by any facts. Avery's experiments about and tests on the RAV4 key suffered similar flaws to his arguments about the hood latch. First, even if the key was a subkey, not even if it was a subkey, quote, that does not establish that the key was planted, unquote. Avery provided nothing establishing, quote, that the key that the victim used on the day of her murder was not the subkey, unquote. Moreover, Ms. Halbach's employer testified that she was, quote, misplacing her keys all the time, unquote. Strang and Buting could not be ineffective for failing to procure an expert to say that the key was a subkey because there is no probability a different result would occur at trial if an expert offered that the key was a subkey without also showing that Ms. Halbach was not using the subkey on the day of her murder, especially when someone who knew her well testified that she was prone to misplacing her key. I just want to note there that that was a really fucking long sentence. And that's something they took a shot at earlier in this, of this really long-winded sentence. Well, that was a really long fucking sentence right there. Second, like its hood latch experiment, Avery's experiment holding an exemplar key bolsters rather than weakens the state's case. False. Avery concluded that his experiment, quote, demonstrates that the DNA on the subkey was planted because the amount of DNA detected by the crime lab, unquote, was much greater than the amount of DNA Avery deposited on the exemplar key by holding it in his hand for 12 minutes. What Avery glossed over was he undeniably left his DNA on the exemplar key during this experiment, which again was obviously conducted in a controlled environment and cannot account for the many other variables that could lead to Avery depositing more skin cells on the key, and with Avery in a different physical condition than one would be when trying to hide evidence of a murder. And as the circuit court again correctly noted, Avery's claim that Avery's, quote, toothbrush was taken by law enforcement from his bathroom, but suspiciously never logged into evidence, unquote, and that was the source of his DNA on the key, was supported only by his conclusory, self-serving allegation. But see, you bitch when they don't give you reasons and explanations, and then you fault when they do and claim there's no proof to it. So which is it? You want a theory or you don't want a theory? Furthermore, Avery has again materially misrepresented Reich's opinion. Reich never once, quote, opines that the DNA found on the Toyota subkey found in Mr. Avery's bedroom was planted, unquote. A citation to where this claim appears in Reich's affidavit is conspicuously absent from Avery's brief, likely because such an opinion is conspicuously absent from Reich's affidavit. There's lots of things absent in this case. Avery cannot obtain relief by falsifying his expert's findings on appeal. Moreover, this theory was put forth at trial and rejected by the jury. There is not a reasonable probability that rehashing this unsupported speculation would produce a different result at a new trial, meaning Avery showed neither ineffective assistance nor what was needed to prevail on a newly discovered evidence claim. Sorry. Finally, Avery's expert reports about bullet fragment, the magic bullet, do not support his position that, that he has, quote, completely disproven, unquote, the state's assertion that the victim's cause of death was being shot twice in the head for two reasons. First, Avery sought to disprove something the state never alleged, that magic bullet went through the victim's skull. No? Then how do you know she was shot? Showing that magic bullet did not go through bone, therefore would not disprove any part of the state's case, even if that were what Palahniuk's report actually concluded. The state's forensic anthropologist, Dr. Leslie Eisenberg, who is a charlatan, and the medical examiner, Dr. Jeffrey Jensen, testified that the cause of Miss Halbach's death was 2 gunshot wounds to her head. Avery's own forensic anthropologist, Dr. Scott Fairgrave, agreed with that assessment. But these experts came to that conclusion by examining the bone fragments recovered from Avery's burn pit, not from anything about the recovered bullet fragments. So then why are those bullet fragments evidence? Dr. Eisenberg found skull fragments that showed, quote, unnatural openings in 2 different skull bones, one in the parietal bone and one in the occipital bone. These openings showed internal beveling, and x-rays of these unnatural openings showed radiopaque flecks surrounding them that were not bone. She testified that to a reasonable degree of scientific certainty, but see, any of their experts don't know anything about scientific certainty. The internal beveling in the left parietal bone and in the occipital bone indicated, quote, gunshot or bullet entrance wounds, unquote. See, this is again, they're putting all these words in there, but this is saying there's no absolute proof that that was even a gunshot in that bone. It is unnatural opening. Dr. Kenneth Olson, the state's trace evidence expert, testified that he conducted an elemental analysis and learned that the flecks around the openings were lead. Dr. Jensen confirmed that the bone fragments showed 2 gunshot entrance wounds to the head, which were the cause of death. No expert found any evidence of an exit wound. None of the experts who testified at trial claimed the magic bullet fragments were used in the fatal shots. What the state submitted about the 2 bullet fragments and 11 casings recovered from Avery's garage was ballistics experts Newhouse's opinion that all 11 casings and bullet fragment, the magic bullet, were fired from the .22 rifle taken from Avery's residence. The other bullet fragment was in too poor condition to tell whether it was fired from that gun. But Newhouse never opined that either bullet fragment went through bone, let alone that they were the bullets from the fatal shots. He simply said that FK, at least, looked like, quote, a bullet that had passed through or has struck some harder object than the bullet, unquote. But that could be anything, and the state's DNA expert, Sherry Big Hair Culhane, testified that Halbach's DNA was found on FL, but she never suggested it had a specific tissue source. In other words, it was the skull bone fragments showing bullet holes in them that the state used to prove that the victim was shot in the head. No, you said unnatural openings, not the bullet fragments. Avery has misunderstood why FL was significant. FL was significant because it was both fired from the gun in Avery's bedroom and had Teresa Halbach's DNA on it, meaning the bullet touched some part of Ms. Halbach's tissue at some point and therefore linked the gun to Ms. Halbach's murder. Are you fucking kidding me right now? So now, all through the trial, they kept saying that this bullet went through her head. And now they're trying to say it just went through some other part of her body. That's how they're trying to excuse that there was no bone on it. Oh, it went through some other part of her body. A complete change in everything they have said. But contrary to what Avery claims, no one ever said that FK and FL were the 2 bullets fired into Ms. Halbach's skull. Avery made that inferential leap on his own. Wrong. Jensen said, as explained, that the bones showed 2 gunshot wounds. He said nothing about FK or FL going through the skull, nor did the prosecutor. Lie. Indeed, the prosecutor told the jury that he could not say how many times Avery shot Ms. Halbach and never suggested that the state had identified all the bullets on all the places on her body she may have been shot. Because only 2 bullet fragments, but 11 cartridge casings were recovered, but the evidence showed that she was shot, quote, at least twice, and it's at least twice to the head. Bullshit. I'm getting mad again. But again, that was because the forensic anthropologist and medical examiner found 2 gunshot entrance wounds in her skull bones. No, it has never been proven those alleged skull bones had bullet holes in them. Sorry, wrong, no. Had no bullet fragments been found at all, the state's argument about the cause of death being 2 gunshots to the head would have remained the same. Accordingly, even if Palahniuk's report about whether bone particles were present on FL were as conclusive as Avery represents, Avery would have disproven nothing. Second, as the circuit court noted, Palahniuk admitted that he could not state with certainty that his observations were inclusive of all types of particles that may be on FL, and further admitted that he could not say with certainty what any of the particles on any bullet, exemplar, or FL was without further scientific testing, right? They want more testing. That's what Kathleen's been asking. We want to test stuff. Putting Palahniuk on the stand to say that he could not state with certainty anything about the absence or presence of bone on a bullet fragment that the state never alleged went through bone anyway would not create a reasonable probability of a different result at trial. You totally told that jury that that bullet that you found that had stuff on it, that had Teresa Halbach's DNA on it, went through her fucking head. That's what the state, Kretz, was alleging. That's what the jury was ruling on. So go back to trial now with a new impartial jury and say, yeah, there's these casings here that Raleigh Johnson testified that he, since that's his gun, he used it all the time to shoot all around there. There's casings all over. Not only Raleigh Johnson's, however you say his name, I always say it wrong. Not only his property, but the salvage yard while they were shooting at varmints. So what? You're gonna say that every casing you find there could have gone through Teresa Halbach? You're just not saying where it went through her. But you have no proof that she was shot anywhere than the alleged skull. So now you're trying to claim that this bullet is showing she was shot more than twice. But you have no proof of that. Yet you keep saying Kathleen has to show you all this proof, but you have no proof of that. But you think you get to state that as fact. In sum, Avery's allegations did not meet any part of the test for newly discovered evidence, and accordingly failed to meet the test for prejudice on his ineffective assistance claims as well. The Circuit Court appropriately exercised its discretion in denying his motion. We are now on page 79 of 130. 3. Avery's arguments do not persuade. Bullshit. Avery alleges that the circuit court, quote, erred in weighing the scientific evidence rather than granting an evidentiary hearing, unquote, and, quote, applied the wrong standard, unquote, to this evidence because it noted that his, quote, arguments ignored an important question: were the tests available at the time of the defendant's previous motion pursuant to Wisconsin statute blah blah, or any of the other appeals or motions filed after trial, unquote. Relying on State versus Edmonds, Avery contends that because the defendants in those cases did not establish precisely when the technology was developed, he only had to show, quote, the technology his experts use now was not available at the time of his trial, unquote. To prove that his evidence was newly discovered, which, as explained, he did not establish anyway, he is wrong. Avery has conflated the standard for prevailing on the merits of a newly discovered evidence claim with the standard for overcoming the procedural bar on a successive section, blah blah motion, to reach those merits. To overcome the procedural bar and reach the 5-prong newly discovered evidence test, Avery first had to show a sufficient reason his newly discovered I'm hearing my dogs barking outside, so I'm thinking maybe Jeff is home. Evidence claims could not have been brought in his other post-conviction litigation. He did not do so. Nothing in Edmonds or Avery supports Avery's conclusion to the contrary. The Supreme Court in Avery did not discuss the procedural bar under section blah blah and simply noted that the parties agreed that the defendant had met the first 4 prongs of the test. In Edmonds, the circuit court found that the defendant had met the first 4 prongs of the test, and this court upheld the determination as a proper exercise of discretion. The unavailability of the defendant's new scientific evidence during his previous appeal was relevant only to the 2nd prong of the test, whether the defendant was negligent in seeking it. Nothing in Avery or Edmonds supports Avery's suggestion that he can meet the first 4 prongs of the relevant test and overcome the procedural bar just by asserting that his new evidence was available at trial. We've already gone through all this. At any rate, the circuit court did not reject Avery's claims on that basis. The circuit court rejected his newly discovered evidence claims on the merits of the 5th prong, as explained above. The court did not improperly weigh the scientific evidence either. A circuit court must weigh the new evidence against the evidence presented at trial to determine whether a jury looking at the new evidence and the old evidence would have a reasonable doubt about the defendant's guilt. Yep. Tons of reasonable doubt. Avery really just argues that the circuit court misread his experts' reports. But the court quoted facts directly from Avery's experts' reports, finding that they did not come to the definitive conclusions Avery claimed in his motion. Those findings are supported by the experts' affidavits in the record. They therefore cannot be clearly erroneous. Avery appears to have misunderstood what Dr. Wright concluded and what the circuit court found about the hood latch source testing. The circuit court did not, quote, conclude that the DNA on the hood latch was deposited by sweat from Mr. Avery's hand, unquote. It noted that Reich's source attribution testing could not test for sweat. And while it is true that, quote, there is no DNA in sweat, we went over all of this already. They really are just trying to, don't pay attention to anything. We're just going to keep doing these circles. Reich admitted that there can be skin cells in sweat, and that is how sweat transmits DNA. Reich couldn't test for sweat, but he ruled out all of the detectable body fluids. Oh my God, I've read all this already. Meaning his test left open the possibility that Avery's DNA was deposited on the hood latch by skin cells transmitted in sweat. Neither the state at trial nor the court said the sweat itself had to carry DNA, which he has now disproven, as he seems to believe. Yeah, Kim, definitely running in circles. Contrary to what he states in his brief, Avery's claim in his motion that Palahniuk's examination of the hood latch swab yielded newly discovered evidence amounted to one sentence that did not relay any facts about what Palahniuk did, what he found, how he reached any conclusions about it, or why any findings he made were significant. And again, the fact that Palahniuk used a microscope manufactured in 2016 does not make the technology new. Yeah, it does. Regarding the magic bullet, Palahniuk only said he couldn't see anything that looked like bone on the magic bullet. But, quote, further analytical approaches, unquote, would be needed to, quote, more specifically confirm, unquote, its absence. Yeah, right. We want tests. That is exactly what the circuit court said, Palahniuk said, and it is far from the definitive conclusion Avery claims. But again, While it's true that, quote, the state's theory as to the cause of death was gunshots to Ms. Halbach's skull, unquote, neither the state nor any of the state's experts ever alleged that the magic bullet was one of the bullets that went through her skull. Avery just jumped to that conclusion. Palahniuk's examination, therefore, disproves nothing, no matter what conclusion he reached about the particles on the magic bullet. And the footnote says, Avery's citation for this proposition in his motion does not support his claim. At two of the points in which he directs the state was discussing how likely individuals are to leave latent fingerprints, not touch DNA. In the third, the state said what Reich said, that sweat sometimes carries skin cells and other material that carries DNA. Avery never alleged in the trial court that DeHaan performed any experiments that amounted to newly discovered evidence. And he offers nothing now attempting to show that DeHaan's independent research since 2012 somehow meets any part of the newly discovered evidence test. Avery just relies on another conclusory, factually unsupported assertion. They're confusing their case. Stating that because DeHaan has performed more experiments on cadavers than anyone else since 2012, they must refute that Ms. Halbach's remains were burned in Avery's burn pit. That would be insufficient to meet any part of the newly discovered evidence test, even if Avery had not forfeited the claim by failing to raise it in the circuit court. The court found that because Avery's experts did not actually rebut anything the state put forth at trial, there was no reasonable probability of a different result at a new trial. It specifically relied on facts stated in Avery's expert reports to come to that conclusion. It issued a reasoned opinion applying the law to the facts of record, or in other words, a proper exercise of discretion. This court should affirm the circuit court's denial of Avery's June 2017 motion. All right, so we are now at 11 p.m. my time, and there's only 47 people on now. I am on page 83. Let me scroll down real quick and see how much of this is actually still stuff. Yeah. So I'm going to call it a night since we're at 11 and I have been doing this for 8 hours. Wait. 9 hours. So let me get you, here's the link again for if you want to go and finish this yourself tonight. I do not know when I will go live tomorrow. Did that go or not? I'm not seeing it. Let me try. Up there it is. Okay. So tomorrow we will start from page 83 and go over the rest of this. So yeah, I don't know when I'll go on. Just stay tuned for when I will jump on to tomorrow to read the rest. And I will talk to Tammy from WMP Justice Review and see if I can get her to comment on this stuff as well, because she's somebody that, you know, I know knows everything about legal stuff, where I am not basically a lawyer, do not pretend to be. So We will finish tomorrow. Thank you, everybody, for tuning in. Know that there were, so we were going over Kathleen's October filing earlier. And so there's 3 or 4 parts of that. So you can find those in the videos here. And then there's this one that's currently at 3 hours and 18 minutes. Oh my God, Dano, it's 5 a.m. there. Yeah. 11 p.m. here. So I'm out. I'm going to have dinner and maybe stare at the TV. And we will talk tomorrow. Bye, everybody. Investigation continues.